And Soupy, are we live? I see the green check mark.
Yes, you are live.
Thank you very much. Good morning, all committee members, members of the public who are joining us today. Welcome to the
Representative Harnett,
meeting of
you're
the Joint Standing Committee on Judiciary.
Representative
Yes.
Harnett, you're breaking up a lot in your connection is bad. I don't know if there's anything you can do to try to improve it.
Give me a second and I will see if I have too many things open. Hold on.
Thanks.
Yeah, that's a good point.
Senator Carney, you are now a co-host if you need to take over.
Okay, thank you very much. We'll give Tom a moment to rejoin us. Thanks a lot, Soupy.
Very welcome.
Is that better now?
Much, much better.
Good.
Well done.
Well, I don't know what I did, but thank you. Again, welcome to the January 20th, 2022 meeting of the Joint Standing Committee on the Judiciary. Just to give you an idea of today's schedule, we will begin with a confirmation hearing regarding the reappointment of the Honorable Julie O'Brien to the Maine Human Rights Commission. We will then begin work sessions after that hearing. We will run those work sessions until 11:15, when we will take a break for an hour. I know that's an unusual time, but some committee members have scheduling issues. We will break at 11:15 and resume at 12:15. I will begin with introductions of committee members as they appear on the list in front of me, beginning with Representative Moriarty.
Thank you, Mr. Chair. Good morning, everyone. I'm Steve Moriarty. I represent House District 45, which is my hometown of Cumberland and part of Gray.
Thank you. Representative Newell.
Thank you, Mr. Chair. Good morning, everyone. My name is Rena Newell, and I represent the Passamaquoddy tribe.
Thank you. Representative Thorne.
Good morning. Thank you, Mr. Chair. My name is Jim Thorne. I represent District 103, which is Carmel, Herman, and a portion of Etna up in Penobscot County.
Thank you. Representative Sheehan.
Thanks, Mr. Chair. I'm Erin Sheehan, and I represent Biddeford's House District 12.
Thank you. Senator Keim.
Good morning, everyone. My name is Lisa Keim, and I represent Senate District 18, which is northern Oxford County and 2 communities in Androscoggin.
Thank you. Representative Babbage.
Yes, good morning. My name is Christopher Babbage. I represent District 8, which is the town of Kennebunk, the hinterland bordering Wells, Sanford, Lyman, and Arundel to one of its beaches. Thank you.
Thank you, Representative Babbage. Senator Sanborn.
Good morning, everyone. My name is Heather Sanborn. I represent Senate District 28, which is half of Portland and half of Westbrook.
Thank you. Representative Libby.
Good morning, everyone. My name is Laurel Libby, and I represent District 64, which is part of Auburn and all of Minot.
Thank you. Representative Evangelos.
Thank you, Chair Harnett. Jeffrey Evangelos, House District 91. I reside in Friendship. And good morning.
Thank you. Representative Galgay-Reckitt.
Morning. My name is Lois Reckitt, and I represent District 31, which is the ocean end of South Portland.
Thank you. And my Senate co-chair, Senator Carney.
Thank you. Good morning, everyone. I'm Ann Carney. I represent Senate District 29, which includes South Portland, Cape Elizabeth, where I reside, and a little bit of Scarborough.
Thank you and welcome all. My name is Tom Harnett. I represent House District 83, which includes the town of Farmingdale and the city of Gardner, where I reside. And I serve as the House Chair of the committee. We will now begin a public hearing. This is a public hearing of the Joint Standing Committee on Judiciary for the purpose of considering the nomination by the governor of the Honorable Julie Ann O'Brien of Augusta for reappointment to the Maine Human Rights Commission. Under the law and joint rules of the legislature, this committee is required to hold this public hearing and to recommend confirmation or denial of the nominee by majority vote of the committee members present and voting. As chairs of the committee, Senator Carney and I will then send written notice of the committee's recommendation to the President of the Senate. The committee will hear testimony from and have an opportunity to question the governor or her representative, the nominee, and any other persons present who wish to speak for or against the nomination. This meeting is currently being live streamed on the committee's YouTube channel. This means that anyone who is a participant in the meeting via Zoom can be seen and also heard if their microphone is unmuted. People testifying cannot be seen or heard until they are called upon to speak and moved over as panelists. This meeting is being recorded and will be available to view on the committee's YouTube channel soon after our day's work is finished. Pursuant to Title III, Section 157 of the Maine statutes, which requires that there be an affirmative motion to recommend confirmation of the nominee, the chair recognizes Representative Sheehan for the purpose of making such a motion.
Thank you, Mr. Chair. I move that the Joint Standing Committee on Judiciary recommend confirmation of the Honorable Julie Ann O'Brien of Augusta for reappointment to the Maine Human Rights Commission.
Thank you, Representative Sheehan. We have a motion. Do I have a second? Seconded by Representative Babbage. For the members of the public, a copy of the statutory requirements for this position is available online and is accessible to anybody who needs to see that. The chair now recognizes Joe Boucher on behalf of the governor making a statement concerning this nomination. Welcome, sir.
Thank you. Good morning. Senator Carney, Representative Harnett, distinguished members of the Joint Standing Committee on the Judiciary. My name is Joe Bushy, and I am Deputy Director of Boards and Commissions for Governor Mills. I'm here today on behalf of the governor to speak in support of the reappointment of the Honorable Julie O'Brien of Augusta to the Maine Human Rights Commission. Julie O'Brien is a native of Augusta and received her degree in Community Leadership and Development, magna cum laude from Springfield College. In 1983, Ms. O'Brien founded the Children's Discovery Museum in Augusta and served as the museum's executive director for more than 20 years. In 1998, she was elected to the Maine House of Representatives, where she represented part of Augusta until 2004. While in the legislature, Ms. O'Brien served on the Joint Standing Committees on Criminal Justice and Public Safety, Health and Human Services, and Appropriations and Financial Affairs. She was also appointed to several select committees, including the Committee on Substance Abuse, the Committee on Children's Mental Health Oversight, the Council on Children and Families, and the Council on the Reorganization and Reunification of the Department of Behavioral and Human Services, where she served as co-chair of the Committee on Children and Families. In 2009, she became faculty in residence for the University of Maine New Women's Leadership Institute. Outside of her work, Representative O'Brien has a long record of leadership and community service, including serving as the president of the board of directors of the National Alliance for the Mentally Ill, a board member of the Capital Area Recreation Association, and a member of the Southern Kennebec Domestic Violence Council. She was confirmed as a member of the Human Rights Commission by this committee just last April to finish the term of a former member. If confirmed today, she would serve a full term. On behalf of Governor Mills, I ask for your support for the nomination of the Honorable Julie O'Brien of Augusta for reappointment to the Maine Human Rights Commission, and I would be happy to answer any questions you may have of me.
Thank you, Mr. Bushy, and I apologize for mispronouncing your name, and thank you.
Quite all right.
bringing this nomination forward on behalf of the governor. Are there any questions from committee members regarding the statement provided by the governor's representative? If so, if you could please raise your electronic hand and I will recognize you for any questions that you might have. And I am not seeing any electronic hands. So again, thank you very much.
Thank you.
For your time today, sir. And I will now move and recognize the Honorable Julie Ann O'Brien for the purpose of making a statement concerning this nomination. Welcome back, Ms. O'Brien. It seems like you were just here less than a year ago.
I was. Was. Thank you. Good morning, Representative Harnett, Senator Carney, and esteemed members of the Judiciary Committee. I am Julia O'Brien from Augusta, born, raised a family here. Boy, when Joe Bushy says, after hearing him talk, it really confirms how old I am. But I thank you very much for the honor of reappointment to the Maine Human Rights Commission. I haven't been gone long enough for you to miss me, but it was last April that I was in front of you. Not much has changed, except that I have served each month on a meeting, which I have to tell you is a huge learning curve. Every month, there's more that there's a light bulb in my head. Oh, that's how it works. But it's very interesting. It's very important work. We have run the gamut of issues. I will say my first meeting, very first meeting, and I was so ready for it. And we lost internet, totally lost it. Couldn't get on. Then I was on, then I was off, then I was on, then I was off. I'm surprised that I'm back here today. But I want to tell you that I also, having served as a Republican, I have to say, when they told me at the beginning, was some of the members said, I don't even know what party the other members are from. I didn't quite believe that, but I can tell you, I honestly do not know. I have been a maverick on votes. I've been by myself. I've been combined with any and all of the other members. So it really is not a partisan thing. It's a philosophy. It's a philosophical, the way you're thinking, I think. So I know that as a former member of the legislature, I know that you appreciate a very concise statement, and that is my concise statement at the beginning of the day. Hope all goes quickly. Thank you very much. I'm honored and humbled.
Thank you very much, Ms. O'Brien. Are there questions from committee members for the nominee? If there are, please raise your electronic hand so that I can recognize you. And I will begin with Senator Keim.
Mr. Chair, thank you for your service, Ms. O'Brien. I just was curious if, just so that more for curiosity's sake, if you could just share with us some of the issues that have come in front of you that were difficult to decide or had more conversation and differing opinions.
Well, yes, I can. We've gone from it's a lot of discrimination in employment, sexual harassment in employment, also a lot of housing issues, whether someone was evicted fairly or not, or discriminated because of their disability, which goes from any kind of mental disability. It's gone transgender rights, students, parents on behalf of their children in a school setting, transgender bathrooms. I mean, all of it. It's a lot.
Thank you.
Thank you, Senator Kime. I will check to see if there are additional questions from committee members. And I am not seeing any, but I do have a question, Ms. O'Brien. Being a local resident, I'm aware that your husband was recently elected mayor of the city of Augusta and sworn in recently. And I'm wondering if you have any concerns about potential conflict of interests arising with your work on the commission and how you would plan to deal on those if those arose.
Well, thank you for that question, and thank you for acknowledging my husband's confirmation as mayor. I actually had never even thought of that because I really can't imagine any conflict at this point. Also, I mean, having served in the legislature when he was on city council, and I mean, it's a small town, a small state, so there's always going to be some, I think there's always going to be some combination of issues, but I really can't think of anything that would be a conflict. And I don't know do you see something?
Well, I could see a potential of a claim being filed against the city of Augusta.
Oh, okay. Well, I would recuse myself, and that has happened with several members at different points. So yes, if that happens, I'm out.
Okay.
Thank you.
Thank you very much for your response. Representative Evangelos.
Thank you, Mr. Chair. Good morning, Julie. A yes or no answer will suffice on this. I don't want to do a deep dive, but the NAMI, the National Association of Mental Illness, were they the subject of any human rights complaints in front of the commission?
Not since I've been there. No.
The issues we read in the paper were not related to a complaint then.
A recent complaint? We haven't seen it.
No,
There are some.
No, not a complaint with, you had some personnel issues.
Oh, way back, yes, when I was involved with NAMI, there were some issues.
I mean, I don't want to, I just wanted to, along the lines of what Representative Harnett mentioned, but that particular issue, which wasn't long ago, did not result in any employees or anybody making a complaint to the commission.
Well, okay, well, I will say that there are very often, very frequently, there are cases that we don't, that have conciliation has happened, and we don't go into them deeply. If there's a unanimous, so I'm not familiar with that at all. I mean, there are so many cases that never get to the point of the commission.
No, I don't think you understand what I'm talking about. Wasn't there an issue with your executive director?
Many years ago? No. Oh, no, that was after my term.
Okay.
So no, if I'm thinking the same thing, no.
No, so that was a personnel issue dealt with internally, but it didn't result in anything before the Human Rights Commission.
Not that I'm aware of, no.
That's all I wanted. Thank you.
Thank you, Representative Evangelos. Thank you for your response, Ms. O'Brien. Senator Carney.
Thank you, Ms. O'Brien. Welcome back.
Thank
and
you.
I just wanted to ask you, in light of this discussion that we're having about conflicts of interest, are you aware of the Commission's conflict of interest policy, and have you kind of refreshed yourself on that policy since your husband was inducted as mayor of Augusta?
Honestly, no, because I've never thought of it. I will do that, but I really didn't see a conflict coming. But I will refresh. Well, I will look into it. Yes, I'll do that. Yeah. But I haven't since he's been. This was just within a month. This has happened.
No, I know it's recent, and I appreciate your indication that you will review it. Thank you.
I will review it. Thank you.
Thank you, Senator Carney. And I will take a look through the committee list again to see one more time if there are any questions from committee members. If so, please raise your electronic hand. And seeing none, I will close this portion of the hearing. The chair will now take comments from persons attending this hearing who wish to speak for or against this nomination. Anyone who has a written statement but who does not wish to speak today should have submitted that statement to the committee clerk prior to today's hearing. All such statements should have contained the name and residence of the person who prepared the statement. A copy of each written statement presented to the committee at this hearing will be made available to the nominee at her request prior to the committee's vote, and the nominee will have an opportunity if she chooses to respond to the written comment. Persons who wish to speak today in person registered with the committee clerk prior to the start of our hearing and will be called upon by the chair, at which time they will be promoted to panelist status in Zoom, where they can be seen and heard. When it is your turn to speak, please observe the following. State your name and place of residence prior to presenting your testimony. Only comments concerning the suitability of this particular nominee for this particular position will be considered in order. All other comments will be considered out of order. After you are done speaking and there are no more questions from members of the committee, you will be returned to attendee status, and any other person who wishes to testify will be called. I only have one person who has signed up to testify, and that is a person testifying neither for nor against. So what I'm going to do now is I'm going to the attendee room, and I ask that if there are any persons who wish to testify in support of the nominee, to please raise your electronic hand so that I might recognize you and move you over to the panel. And seeing none, I would now ask if there are any persons who wish to testify in opposition to the nomination to please raise your electronic hand so that I may recognize you and move you over as a panelist. Seeing none, I will now go to my list of people who have requested to testify neither for nor against, and ask the committee clerk to please move Amy Sneerson from the Maine Human Rights Commission over to panelist status. And once she arrives, I will call upon her to provide testimony.
Good morning.
Good morning, Ms. Sneerson. How are you today?
Good morning. I'm well. How are you? Actually, I forgot this isn't actually a conversation. Sorry. Thank you for allowing me to appear. I'm really only here to answer any questions if there are any, just as back in the day when we were physically at the State House, I would be in the room in case there were any questions. But other than that, that's all. Thank you.
Okay. Thank you, Ms. Sneerson. Could you just for the public state your name and title?
Yes. Sorry about that. I'm kind of out of practice. My name is Amy Sneerson. I'm the Executive Director of the Maine Human Rights Commission. The staff who work with the commissioners, one of the seats that Commissioner O'Brien is being reappointed for. Sorry, and thank you.
Well, we're all out of practice. There's no need for apologies. Thank you for being here. Are there questions from committee members for Ms. Sneerson, the Executive Director of the Maine Human Rights Commission? If so, please raise your electronic hand and I will recognize you, and I will begin with Representative Chris Babich.
Thank you, Chair Harnett. Good morning, Ms. Sneerson. Could you just, give us a quick summary as to the number of members on the commission and the time commitment that is involved? I understand they have monthly meetings. I'm sure you send information ahead of time, but what is the duration of the meeting and so forth? Thank you for that.
Thank you, Representative Babbage. There are 5 appointed commissioners. They serve 5-year terms. A seat comes open each year and is appointed by a governor. No more than 3 commissioners can be from any particular party. As Commissioner O'Brien noted, we are nonpartisan and intended to be that way. The time commitment, that may be a better question for Commissioner O'Brien. I know we can, at a particular meeting, we have about 15 minutes of business discussion at the start of the meeting, and then any cases that are being heard by commissioners, and that can be 4 cases or it can be 12 cases. There are times when a meeting is done in 2 hours, and there are times when it takes 8 hours, and we have a morning and afternoon session. We also have a consent agenda of cases that no party has opposed our recommendation, and so those are all adopted. The recommended decisions are adopted with one motion. I think we do in advance, about a week ahead of a commission meeting, we upload to commissioners, we provide them, we used to do it all on paper, now we do it all electronically. We give them each an iPad, and about a week before the hearing, we upload all the information on cases that commissioners will be hearing arguments on, and all of the cases that they'll be voting to adopt recommended decisions, and other matters that we need them to make determinations about pending or anticipated litigation, or if there are other personnel matters or other executive session matters. So, I mean, they do a tremendous service to the people of Maine, giving their time. All they get is a $25 per diem. I think it's hours and hours of preparation, and then hours on the day of the commission meeting. We have 11 meetings per year.
Thank you very much.
Thank you, Representative Babbage. Are there additional questions from committee members? I'll take one more look at the room. Please raise your electronic hand if you have any questions. Seeing none, thank you very much, Ms. Sneerson, for your availability today and your participation. We greatly appreciate it.
Thank you.
Seeing no additional persons, I'm sorry, I will check the attendee room one more time to see if there's any other person who wants to be heard on this nomination, and I am seeing none. Therefore, all public comments having been taken, the committee will now proceed as follows. We will review any additional written comments on the nomination that have been received by the committee clerk since the beginning of this hearing. Are there any such filings, Committee Clerk Panett?
There are none, Mr. Chair.
Thank you very much. We will vote on the nomination and notify the President of the Senate pursuant to Title III MRSA, Section 157, and the joint rules. This vote must be taken within 35 days from the date of the governor's written notice of nomination, and we are within that time frame. The hearing by the Joint Standing Committee on Judiciary for the Honorable Julie Ann O'Brien of Augusta for reappointment to the Maine Human Rights Commission is closed. In accordance with the law, the committee may not take the vote on this nomination sooner than 15 minutes after the close of the public hearing, unless all committee members who are present agree. Therefore, at this time, I will ask whether any members present object to proceeding to take the vote immediately. If so, please raise your electronic hand so that I can recognize that concern. And I am seeing none. There is no objection, so therefore we will move forward. The pending question before the committee is that the Joint Standing Committee on Judiciary recommend to the Senate of the 130th Maine Legislature that the nomination of the Honorable Julie Ann O'Brien of Augusta for reappointment to the Maine Human Rights Commission be confirmed. In accordance with 3 MRSA Chapter 6, Section 157, and with the joint rules of the 130th Legislature, the vote will be taken by the yeas and nays. A vote of yes will be in favor of recommending confirmation. A vote of no will be against the motion to recommend confirmation. Is the committee ready for the question? I would ask the committee clerk to please call the roll. Ms. Panett?
Thank you, Mr. Chair. It will be my pleasure. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Newell.
Yes.
Representative Newell votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Poirier. Senator Keim.
Yes.
Senator Keim votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Carney.
Yes.
Senator Carney votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Hagan. Representative Libby.
Yes.
Representative Libby votes yes. I will recall the absentees. Representative Poirier. Representative Poirier is absent. Representative Hagan. Representative Hagan is absent. Mr. Chair, the roll call is complete.
Thank you very much, Supi. 12 members of the committee having voted in the affirmative and 0 in the negative. It is the vote of the Joint Standing Committee on Judiciary that the nomination of the Honorable Julie Ann O'Brien of Augusta for reappointment to the Maine Human Rights Commission be confirmed. Ms. O'Brien, congratulations. On behalf of the committee, I extend our heartfelt appreciation for your continued public service, and we wish you the best moving forward.
Thank you very much. I neglected to say something, and it was right at the top of my notes with exclamation marks that the staff of the Maine Human Rights Commission, from Amy to the investigators to the attorney, you have an amazing group of people there. They work so diligently, so hard, and we do get preparation materials that, I mean, voluminous, that they have prepared. So I really needed to say that. So thank you very much.
Thank you. And this committee is also blessed with great staff, and we know that those are the people that really make the operation work. So I appreciate that. Typically, it feels like ancient history now, but we would be coming out from our horseshoe and coming down to congratulate you personally on this accomplishment and your reappointment. But today we will offer you our virtual round of applause for your thanks for your continued public service and our congratulations.
Congratulations, Julie.
And thank you very much. And at this point, I will turn over the gavel for our work sessions to my co-chair, Senator Carney.
Thank you very much, Co-Chair Harnett. We'll just give everybody a moment. Okay, so we're back to committee members and our analysts on the screen here. And good morning, everyone. This morning, we're going to do a series of work sessions on bills. And as Co-Chair Harnett indicated, because of some scheduling concerns, we are going to take an hour break from 11:15 to 12:15. And let's see. We will begin with, I have another scheduling announcement, actually, is that we had scheduled what we had listed as a work session on LD 1862 to re-reference it. We're still trying to get clarification on the process for doing that, but because there is some lack of clarity, at least in my mind right now, we're going to not do anything with 1682 right now. 1862 right now. And we're going to move on to a work session. We have a request by a sponsor, Senator Searway, to take the work session on LD 1581 out of order. And to accommodate our colleague, we are going to start this morning by opening the work session on LD 1581, an act to require telecommunications companies to divulge location information to law enforcement when necessary. And we our committee analyst, I did not update her. And so Peggy, I apologize for not having a moment to reach out to you, but if you could please begin the bill analysis on that bill, and I will bring the bill sponsor, Senator Searway, over to the panel.
Sure, thank you very much. Not a problem. And I knew that Senator Searway had requested that you take it up a little bit earlier. So LD 1581 creates a new section in Title 35A, which is the utilities title, and it directs, it requires a communication service provider to respond to the request of a law enforcement officer with regard to location information of a wireless electronic communication device. When that device was used to make a 911 call requesting emergency assistance, or if it's if the law enforcement officer reasonably or if the telecommunications device is reasonably believed to be in the possession of an individual that the law enforcement officer reasonably believes is in an emergency situation that involves the risk of death or serious physical harm to the individual. And then there's a provision that provides that that communication service provider is immune from any civil or administrative proceeding for turning over that information. That is kind of some standard language that has been adopted in several other states. In Maine, however, we already had a telecommunications location statute, electronic device location information. It's in Title 16, which is the laws governing evidence. And it generally requires a warrant to access that type of location information, but there are exceptions to that warrant requirement, and those are when a government entity can obtain the information without a warrant to respond to the user's call for emergency services. So that's kind of parallel to what's in the bill about somebody making a 911 call. When there's consent of the owner or user to access that location information. If there's a consent of the family member when the owner or user is believed to be deceased or reported missing and unable to be contacted. Or if the government entity reasonably believes that an emergency involving imminent danger of death or serious physical injury to a person requires the disclosure without delay. So if that's the situation, that last dangerous death or serious injury, the government entity goes to the communications provider, and they have to determine that a warrant cannot be procured fast enough. They can go to the possessor of the location information and ask for it. And if the possessor of that information in good faith believes that such an emergency exists, then they turn over the information. And if that happens, then the government entities that's asking for that information needs to file information with the court that says, instead of asking for a warrant in this situation, we ask directly for the information from the possessor of the information. So the current law is a little bit broader in two ways. One, it applies to a government entity, and that can be a state or local agency, including or not limited to a law enforcement agency. And it also covers more than, I mean, the language is a little different. It's about who possesses that information as opposed to a telecommunications provider. It also differs from the bill because it gives the possessor of the information the opportunity to consider whether or not they believe that an emergency is occurring. And if they in good faith believe that that's happening, then they turn over the information. But if they don't believe that it's an actual emergency, they are not required to turn over the information. Current law also provides that the law does not create a cause of action against the corporation or its officers or employees or agents for providing location information pursuant to the subchapter.
Thank you. Committee members, are there any questions for our analyst? I am not seeing any questions. I actually have a question for you, Peggy. I just want to confirm that. So we have an existing statute that confers actually even slightly broader access to this information in emergency situations. And that is currently in use and effective, according to the testimony from the Maine State Police.
Yes, I think the testimony was that they haven't had a problem accessing that information when they thought it was necessary.
Thank you. Any other questions, committee members? Representative Newell?
Thank you, Madam Chair. Peggy, did I hear you correctly by saying that it was not limited to law enforcement?
Right. The current law defines government entity as a law enforcement entity or any other investigative entity, agency, department, division, bureau, board, or commission, or an individual acting or purporting to act for or on behalf of a state or local agency.
That's contained within the current law?
Current law, yes. And I have posted the current law in the portal.
Okay. So is that the same in this proposed?
No, I believe the bill limits it to law enforcement.
Okay.
Yep, a law enforcement officer.
I have a
other follow-up.
Yes, please. If you were to compare the proposed law to the existing law, is this law to allow quicker access in determining locations? Whereas in the current law, is that subject to additional, I don't know how to phrase it. Additional.
So are there additional hurdles or blocks or, so the bill does not give the entity that has that location information the discretion to say, I don't think an emergency really exists, and so I'm not handing over that information. That is in the current law, and there has not been any delays that have been reported about turning over the information. So maybe that means that all the requests that have been made are considered to be legitimate requests for the information.
Okay, thank you.
Representative Moriarty?
Thank you, Madam Chair. Peggy, I want to clarify, when you speak of the current law, are you speaking of Title 16, Section 650?
Yes, that is the exceptions to the warrant requirement. In all other situations, a warrant is required for this information.
Okay. Let me ask if you agree with my quick analysis. The current law says that a government entity may request this information, but there is no automatic obligation on the part of the service provider to, in fact, provide the information. The request can get conceivably passed up the chain of command until you reach an individual who has enough corporate clout or whatever to say yes or no, and only then will the information be transmitted. By contrast, the bill says that the service provider shall provide information in response to a request from a law enforcement officer. Is that a fair distinction?
I think it's a fair distinction to say that the bill says shall, upon request of a law enforcement officer, when presented with the request. I don't know the inner workings of an entity that holds this location information, so I don't know what their process is for evaluating whether that request is meets the definition in the statute. also the current law is really focused more on evidence and the ability of law enforcement to access that information. So if one of those situations does not exist, what the current law says is the law enforcement agency, the law enforcement officer has to get a warrant in order to get that information. So that's the focus of the current law.
And again, by contrast, the focus of the bill is simply cell phone location without regard to what the cell phone contains.
Well, current law, that section, this subchapter.
Did I say current law? I meant to say the proposed bill.
Both, but both the current law and the bill focus only on device location information. There's a completely separate subchapter dealing with the content of electronic devices.
Okay. Okay. Thank you then.
Representative Harnett?
Thank you, Madam Chair. I will be making a motion ought not to pass, but I want to speak briefly to the motion. This hearing was an incredibly emotional day for me, and I know it was for other members of the committee members, other committee members, and also for the families, the family who had lost a daughter under horrific circumstances. But I was struck during the day throughout the hearing with the testimony of our law enforcement agencies stating that this is not a problem in Maine, that the statutes that we have on the books and in effect right now address this situation in a timely fashion, and that this bill would not add anything, would not add arrows to that quiver. I am not personally a fan of enacting laws that are not needed, that may even be superfluous. So I think that the problem that this bill is trying to address is addressed under current law, and for that reason, I am making the motion ought not to pass.
Thank you, Representative Harnett. Is there a second? Seconded by Representative Evangelos. Thank you, Representative Harnett. And I just wanted to follow up on what Representative Harnett said. The Maine State Police testified that us passing this would just be, quote, symbolic, I think was the word they used. And it would also involve requiring our law enforcement and other agencies to change a system, and that all of the training that goes into helping people understand that system, to change that system to a new system. And I just don't think that we've seen or heard anything that would justify that. And I know that the bill sponsor would like to speak. I just saw you raise your hand, Senator Searway. Representative Thorne and Senator Sanborn have their hands up. So let me call on them and then we'll get to you shortly. Go ahead, Representative Thorne.
Thank you, Madam Chair. Once again, a Republican-sponsored bill gets its knees cut out from it before we can even get through all the committee members that would like to speak for it. Just an observation. I can't help but think about all the other bills that are symbolic that we are dealing with in committee this year. I don't know if there is anyone, before we hear from Senator Searway, in the waiting room, perhaps a different perspective of the practical application that this would facilitate rather than what's currently being done, how it might help. If there's a way that we can do that before we go to a vote, anyone from law enforcement or sheriff's office or somebody that we could identify and possibly bring on and ask them. I know that Senator Searway is anxious to speak after having heard good Representative Co-Chair's motion. But before we do this, I'd really like to scour and see a different opinion from practical application from law enforcement, other than Senator Searway, who obviously will have pertinent information to provide to the committee.
Thank you, Representative Thorne. I do want to get to the bill sponsor, and I would ask Senator Sanborn if you could, you were next, if you could quickly address the committee, and then we'll move on to the bill sponsor.
Thanks, Senator Carney. I just wanted to second what Representative Harnett had said and say that, you know, when we have these big national bills that are written at the national level and that solve a problem that presented itself in another state, really have to look closely at whether Maine has found a different and perhaps equally or more effective solution prior to the movement that brought the language forward. And I think that's one of the situations we find ourselves in here today. It's in a different section of the statute, but it's operating just fine. And we don't have a live problem that we're trying to solve. And so moving the text to a different place or updating it in a way that doesn't solve a live issue in our state can be dangerous, and particularly where we're on the edge of a right to privacy, on the edge of a concern about protecting folks and their personal privacy and their devices. We do need to be very careful about how we change the law. And so I would not be in favor of this bill and would vote in favor of the pending motion. And just to reference Representative Thorne's point, I don't think anyone has suggested that we're cutting the hearing off just because Representative Harnett has made a motion. It's quite common for us to have a motion on the table as we continue to discuss a bill. And I look forward to hearing from all of my colleagues, except for the fact that I have to leave in 4 minutes to go chair another hearing. So when I do disappear, I want folks to know that it's only for that reason and no other reason. Thank you.
Thank you, Senator Sanborn. And next we will hear from the bill sponsor, Senator Searway. Welcome back to the Judiciary Committee, Senator.
Good morning, Senator Carney, Representative Harnett, and members of the Joint Standing Committee on Judiciary. Thank you for the great questions you've asked during the public hearing on LD 1581. The legislation requires a telecommunications service to provide, upon the request of a law enforcement officer, the location data of wireless device used in place of a 911 call requesting emergency assistance, or when there is reason to believe someone is at risk of death or serious harm. In its original drafting, the bill also provides immunity from civil and administrative action by a government entity for providing location data. After the hearing and thinking about your questions, I believe there is a way to amend this bill while still achieving the goal of attaining the location of a person's wireless device when it is believed that the individual is in serious danger. This new proposed provision would be located in Title 35A. I've had conversations with Major Bill Ross, who stated he was for this change, even though the Department of Public Safety has not in recent years experienced any issues in getting this information. I agree that times have changed and most recent requests have been made successful. That said, we have a large variety of cell phone providers, and the person assigned to this may interpret the current language that he or she may not have to give out the information to the law enforcement officer due to the language in Title 35A under paragraph 1 and 4, which should have shall instead of may to clear up the misunderstanding. In Title 16, Section 650, I believe a part of the subsection 4 needs to be removed to match up. this section would then read, as in 4, danger of death or serious injury. If the government entity reasonably believes that the emergency involving imminent danger of death or serious physical injury to a person requires the disclosure without delay of location information concerning a specific person, and that a warrant cannot be obtained in time to prevent the identified danger. And then cross out, and the processor of the location information in good faith believes that the emergency involving danger of death or serious physical injury to a person requires the disclosure without delay. There's a question there. And then within a reasonable period of time after seeking disclosure pursuant to this subsection, the government entity seeking the location information shall file with the appropriate court a written statement with setting forth the facts given rise to the emergency, and the facts is why the person whose location information was sought is believed to be important in addressing the emergency. I listened to the ACLU concerns. Many of the concerns are more from data collection issues. For example, Carpenter versus Riley case should be clarified, which was brought up. I understand this case to be about tracking and getting large amount of data for a long period of time. Asking for more than 7 days worth from a cell phone, you need a warrant. In LD 1581 is only one point in time asking for a location, and that is it. There are many other issues that do not require a warrant. Mental health issues. How do you get a warrant without no crime? A victim of a crime. I believe you do not need a warrant on a victim. There's no probable cause is needed on a victim. So this bill, LD 1581, is purely about protecting the individuals that are in serious danger. That is the motto for law enforcement, is to serve and protect public safety. I also recently spoke to Missy Smith, the mother of Kelsey, and she stated that just this last year, a situation happened where a telecommunications provider refused to give the information without a warrant, and the individual was found deceased. This is what we all want to prevent. I would like to request Paul Rusha from the Attorney General's office to speak on these issues I mentioned. I know he cannot weigh in as being for or against, but I believe Paul can clear up the language needed to fix the issue. And if you want more details on Carpenter versus Riley case, this would be the guy to ask. Finally, I would add that through this process, I've heard from the Sheriff's Association and the Chiefs Association. Both support this change in the bill, and you should have been sent the testimony from them along with DPS, Department of Public Safety, so you have all three law enforcement entities for this bill. Some may be on today and willing to answer any of your questions. Again, I would request that you have Paul Rusha come up after me, who has the history of dealing with many sexual abuse cases as an assistant DA in Superior Court, to explain what can be done to clear up the language. Thank you for your time, and thank you to Peggy for who helped with drafting of the proposed language changes in Title 16, and I will be willing to answer any questions you may have.
Thank you, Senator Searway. I will bring Paul Rusha over, but I wanted to ask you if you had available a copy of the amendment that you're proposing, so that we could screen share it so that committee members could see it.
I think Paul may have that for you, so I think he's been working on that.
Okay. All right, well, let's bring him over. And I know that there are a number of hands up committee members, but I think Since the sponsor has asked us to bring Paul Rusha over, I would very much like to do that before calling on anyone so that we can hear from him.
Thank you.
He is joining the panel. It just takes a moment, everyone. Welcome to the Joint Standing Committee on the Judiciary. If you could begin by introducing yourself and telling us your title. And then I know you've been listening to Senator Searway. If you could speak to the amendment, please.
I can. Thank you very much, Senator Carney and Chair Harnett.
Could you please activate your video? You were on video a moment ago and now it's off. Thank you.
Sorry. I saw it was off, so I turned it on and apparently that turned it off. My name is Paul Rusha. I'm currently in the Attorney General's office. I'm not representing the Attorney General's office or the Attorney General at this hearing. In my role, I work with the Maine State Police Computer Crimes Unit, which deal with this area, basically getting digital evidence from electronic communication service providers. Some members of the panel may remember that back in 2013, subchapter 11 and subchapter 10 of Title 16 were added by the legislature, and the location section, subchapter 11, was actually, Maine was one of the first states to actually pass that. So we were ahead of Carpenter in regards to the location information. So when I saw Senator Searway's bill regarding getting this information, my concern was to reconcile Title 16 with what his intent of the bill is. I believe that can be done. I think Peggy has done a more than admirable job in regards to showing or pointing out to the committee where the conflicts are. It really goes to what the definitions are used in Title 35A and then what they are in Title 16. But in general, Title 16 does, or basically is what we use with law enforcement and government entities in regards to getting this information, and specifically location information. So I do want to respond to, I believe it was Senator Thorne's comment, and where I do work with the Computer Crimes Unit, and they work with the main major crime units, basically the ones that investigate homicide. I specifically reached out to them last night to find out if they agreed or if there are any issues that they know in regarding getting emergency information. The two experts that work in computer crimes that do this when there are emergencies did respond to me. One indicated that in a homicide relatively recently, there was a request to a cell phone provider regarding a homicide and trying to get the information. The provider indicated, and I'm characterizing, basically the victim is dead, there's no longer an emergency. In another provision where they were trying to get it from what I would call an electronic communication service provider, or what you would think of as Google or Facebook, it was much more of they gave a little bit of information and the officer had to continue to go back, provide more details about what the emergency was to get more information. And they went back and forth a number of times in order to get the information. Both of the experts provided that to me, that the larger, not necessarily the cell providers, but the larger electronic communication service providers are pushing back, if you will, in regards to getting location information in an emergency. As Peggy pointed out, the issue between the proposal that Senator Searway has and the current Title 16 is the discretion of the ESP to get the information. So the question is whether the legislature wants to have that in there or not. And as I indicated, that's not my role to give any advice for that. I just wanted to respond to Senator Thorne's information. Can I answer any questions for anyone?
Thank you very much. Representative Babbage, is your hand up with a question for Paul Rusha, or was it up previously?
Actually, I will ask him a question if that's possible.
Yes, and just to before we do that, to clarify, Mr. Rusha, are you here on behalf of the Attorney General's office?
I am not. I am here. The Attorney General is aware that I listened to the bill when it was at the public hearing. He's aware that I'm aware there's a conflict between the proposed language and Title 16, and that basically my role here is to make sure that we have laws that are reconciled.
Thank you. And so you're here in your individual capacity?
That's correct.
Okay, thank you. All right, Representative Babbage, you can go ahead with your question.
Thank you. The intent of our current law, as I understand it, is to save someone's life, or if we believe someone is in imminent danger of death or serious physical injury. So in the case where the victim is dead, why would this provision apply?
Depends on the circumstances, of course. It can be, for example, if the murderer or the person who just killed the victim is now on the run and they're trying to find that location to basically take that person into custody, and they believe that the public is in jeopardy from that individual, they could request this location at the same time. But again, one of the provisions of Title 16 is it has to be an emergency situation and there can't be sufficient time to get a warrant.
Thank you. And I think it's narrowly tailored that way, rightfully so. Otherwise, we get into privacy issues and rights of the accused. But thank you for your testimony, Mr. Rusha.
Representative Moriarty, go ahead with your question.
Thank you, Madam Chair. Mr. Rusha, in Title 16, is there an actual obligation on the part of a service provider to transfer the location information? Or does it simply open up the door for them to do so upon request?
There is nothing in it saying that they shall turn it over. If they believe the emergency doesn't exist, they don't have to turn it over.
And one of the anecdotes you just related to us, as I understood it, basically involved corporate hierarchy and bureaucracy and so forth. Is that something you're seeing more of, or?
I can only tell you what from my conversations with individuals of the Computer Crimes Unit. And one of the information that was relayed by him, I think is adequate and appropriate. It's in the middle of the night. He calls the compliance officer at whatever provider it is. And you could get a compliance officer who is only working a night job and has not been with the provider for a long period of time. Or it could be someone who's been on for 20 years and they understand what circumstances can apply. And that's, it's human nature. You're going to get who you get on that phone call. So it depends on that person's experience, what the responses tend to be.
Okay, thank you. Madam Chair, may I ask a question of you?
Yes.
Of course, we received Senator Searway's letter during the course of our confirmation hearing between 9 and 9:30 this morning, and I couldn't multitask sufficiently to listen to the hearing and read the letter simultaneously. Is there, in fact, an amendment pending presented to us?
I don't know. And so I think that that's a very good question. And I think it would be very helpful to the committee to see if there is specific language. And Peggy, do we have a specific amendment do you have a specific amendment that you're able to screen share with us?
That would be up to Senator Searway.
I believe Paul, he was working on an amendment, and I believe maybe he might be able to do that. I don't know.
And Mr. Rusha did share the work that he was doing with Senator Searway with me. And I do have that, and I can share that with the permission of Senator Searway.
Yes, that'd be fine. And maybe Paul can explain it.
Whoa.
And so while that's coming up, I just had one clarifying question that I wanted to ask you, Mr. Rusha. You had referred to both internet service providers as well as Google and Facebook, and Google and Facebook are not internet service providers. Is that correct?
I apologize. If I said internet communication providers, I should not have been. It should be electronic communication service providers. That's what's defined in Title 16. I believe that's more expansive than what's in 35A, which goes to telecommunications. It could include the same entities, but I don't believe it necessarily has to. I believe Title 16 clearly goes at electronic communication service providers, and Google, Facebook, and cell phone providers are electronic communication service providers.
Thanks for that clarification. That's helpful. Peggy, I'll turn it back over to you.
Right. Well, I'm hoping. Can everybody see this? Is this what you sent me, Paul? Right?
It is, and it was it is nowhere near what. And I apologize. It was to get to Senator Searway, basically a proposal of how two of the provisions in the existing Title 16 can remain as a may obtain if there's consent of the owner or user, consent of a family member, but still make it shall for an emergency 911 call or for a danger of death or serious physical injury. I should point out that the big difference, at least that I see between Title 35A and Title 16, is that uses serious physical harm, whereas the legislature back in 2019 changed in Title 16 to make danger of death or serious injury included the sex crimes and kidnapping to ensure, basically to handle a specific issue that we were having. So it is expansive and includes other issues where a victim may be in pretty imminent danger.
Can I just ask a clarifying question to you, Mr. Rusha? You said, well, first of all, is this is a change to Title 16 that you're proposing?
Title 16, Section 560. If you look at the existing statute, you'll notice that those four provisions are in and follow may obtain. And what I did is I broke it very quickly to say shall versus may. But the rest of the language stayed the same with the exception of pulling out the discretion of the provider in what in the draft is in B2 or BII.
Yeah, and you were saying, you said it is more expansive, and I wasn't sure if the it was 35A or the new language that you've
Title 16
added to 16. Could you clarify that, please?
Certainly. Title 16 goes for location information. I believe, or at least my interpretation would be electronic communication service provider is more expansive than to a telecommunications provider that's in Title 35A. The definitions are different between the two titles.
Right. Thank you. Let's see, Senator Searway, did you have any comments before we turn to committee member questions?
I think Paul hit it on the nose on what needs to be done on this, and I'm okay with that, the changes.
Thank you. Representative Babbage, your hand is up. Go ahead.
Yes, I would ask Peggy or anyone who could answer actually, if current law it is permissive regarding compliance. Because as I read current law, it says the government entity may. It's the government entity that has the choice of whether to go forward with this or not. And that if law enforcement merely cites the passage of law in their request when they should have this on them and say in imminent danger or death of serious physical harm. And I don't see permissiveness with regard to compliance anywhere in the law.
If I could just address that, I think Representative Babbage has been reading statutes very long, so he knows that that's what this may right here. I'm showing you the current law right now. That's what this may is right there. That gives the government entity authority to obtain location information without a warrant. Changing that to shall just says they don't have discretion in any of these situations to seek that information, that they have to get that information to respond to a user's call for emergency service, et cetera. It doesn't speak to changing this verb here, or this authorization does not change who's responding or the obligation on them to respond. So, and what I've highlighted here is the language that is in the current law that is not in the bill with regard to the good faith belief of the possessor of that information that it's appropriate to turn over that information. That's the most significant difference, I think. Yes, there are differences in the definitions and who it applies to, but this might be the biggest difference. And I'm not sure. I mean, it sounds like it might depend on who you're contacting, who has that information as to how quickly they make that assessment and turn over the information.
Thank you, Peggy. Representative Babbage, are you all set?
Yes, thank you.
Representative Moriarty, go ahead.
Thank you, Madam Chair. It occurs to me that we have two contending parties in this scenario. The first is a law enforcement officer and or a governmental entity. The second is corporate America in the communications field, which is and will be litigation conscious and may just, as I suggested earlier, pass this up the chain, taking some considerable period of time, and the harm may be done in the interim. I'm not sure that the amendment we saw a moment ago, which says that the entity shall obtain, actually imposes a duty on the provider to provide it. I can see representatives from the corporate structure saying, yeah, I see that your law says that you shall obtain it, but it doesn't tell me that I have to provide it to you. I really thought, Senator Searway, that your original bill was better in that regard. So I guess that's more of an observation than a question. I'll conclude with a suggestion, which is neither here nor there, but my feeling is that this probably should be tabled because number one, we haven't seen the amendment in a realistic way, meaningful way. And I think we need to understand more thoroughly the integration between Title 35A and Title 16, I think there probably is a solution. But I think that solution must address the duty of the provider when requested. I will not make a motion to table because that cuts off debate and discussion.
Thank you, Representative. And I just wanted to point out that what we've heard is that you referenced the word solution, and I think we haven't heard that there's a problem. I think what we've heard is that we have a law that everybody understands and that it currently is working well in our state, at least.
Well, my thinking is that part of Senator Searway's original bill pertained to the situation where someone placed a 911 call requesting assistance, but apparently the location of the cell could not be determined. That can happen at any time. And as cell phone usage continues to spread, as hopefully broadband coverage continues to spread, I don't think it's unrealistic to find that this scenario will occur in Maine, as it has in a number of other states, 30 of which have enacted the Kelsey Smith Act, according to what we heard at the public hearing. So we're not immune from that kind of situation, even though it may not yet have happened.
But I think the point was that in the situation that sadly Kelsey Smith's parents faced in Maine, that information could have been obtained and provided very quickly if that situation were to happen today. I think that's the point, that's what our current law allows to happen.
Well, it certainly allows the request to be made. I'm just not sure it imposes the duty to provide. That's my principal hang-up.
Okay. Representative Poirier?
Thank you, Madam Chair. And just to piggyback on Representative Moriarty's comments there, I agree that this bill does deserve more consideration just for the fact that currently companies are willing to cooperate, but it doesn't mean a year or 2 years down the road they're going to continue to do so. So this bill can definitely be considered proactive in the means of keeping people safe. And I also see that it creates the uniformity and requiring compliance. So I do think that when people's lives are at stake, that it's our duty to be proactive and make sure that that stays the case. So I would definitely support Representative Moriarty's feelings as far as a possible tabling motion when everybody is through with their comments.
Committee members, are there any additional comments? I'm not seeing any hands raised. Okay. Representative Harnett, Representative Harnett, go ahead, and then Representative Babbage.
Thank you, Madam Chair. And as the person who had made the motion, I just want to speak for a moment. One, in terms of process, my motion was not to cut off the knees of any bill, regardless of who it was introduced by in terms of political party. It was to engender this exact type of discussion that we've been having for the last 45 minutes. And my motion was based on the material that I had in front of me, which was LD 1581. I was unaware of an amendment that apparently arrived at 9:22 when I was conducting a confirmation hearing for the Maine Human Rights Commission. And we're now talking about something that's completely different than what was introduced and what was the subject of a public hearing. And I understand how amendments can happen, but I can't discuss an amendment that I haven't seen. And my motion was limited to the bill that was before us. I can't control if there will be a motion to table or not, but I wanted to explain the genesis of my motion and what it was based on. And it's based on the original bill and the testimony that we heard about the reality in the state of Maine. So thank you.
Thank you, Representative Harnett. And I did want to point out that often a motion is made to frame the discussion of the committee. And it, again, is to initiate a conversation rather than to cut off conversation. Representative Babbage, go ahead.
Thank you, Chair Kearney. Yeah, you touched on what I was going to say, but let's look at partisanship for a moment with regard to motions and so forth. I think probably the only advantage of
Representative Babbage, I apologize for interrupting you, but it's 10:30. We have a lot of bills to do work sessions on, and I would just ask if you could focus on the bill that
I
we're
am
currently
going
in a
to
work
focus
session
on the
That
issue
would be
brought up by
appreciated.
a
Thank you very
representative
much.
of our committee. And I just wanted to say that the prerogative of the chair is to get a motion on the floor. And I thought our House chair was actually being very transparent in letting the rest of the committee know. And you can see that there was even some deliberation among the majority party about where we should go on this. So it's not like anything was trying to be forced upon anyone. But the chair's option could have been to make a motion at the 11th hour, which would have been unfriendly to some folks that might disagree.
Representative Babbage. Representative Babbage, I'm just going to ask you to please focus on the merits of the bill that are before us. Thank you. And you'll have to unmute yourself. I'm sorry. Representative Babbage, you'll have to unmute yourself. We're not able to hear you.
Okay, I'll try again. I just wanted to thank the chair for letting us know where he was going early on in the process so that we could respond to that. Thank you, Madam Chair.
Thank you. Representative Harnett?
That was a latent hand.
Thank you. Representative Libby?
Thank you, Madam Chair. Given the amendment that was presented this morning, I would personally really appreciate the ability to see what that amendment would do with where that is in the existing law. I'm having a little confusion about where the amendment would be and the exact effect to current law. And so it would be very clarifying to see perhaps a side-by-side from Peggy as far as what the actual effect is. But I would move to table until we can get that in front of us so that those of us who are still having some confusion could have that clarified.
Thank you, Representative Libby. So there is a motion to table. Is there a second? Representative Newell? Seconded by Representative Newell. And committee members, I'm going to ask our committee clerk to take a roll call vote on the motion to table this legislation. Thank you very much. Clerk Panett, you can go ahead with the roll call.
Thank you, Madam Chair. Representative Galgay-Reckett. Representative Newell.
Yes.
Representative Newell votes yes. Representative Evangelos.
No.
Representative Evangelos votes no. Representative Poirier.
Yes.
Representative Poirier votes yes. Senator Kine. Senator Sanborn. Senator Carney.
Yes.
Senator Carney votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Sheehan. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Hagan. Representative Libby.
Yes.
Representative Libby votes yes. I'll recall the absentees. Representative Galgay-Reckett.
Yes.
Thank you very much. Representative Galgay Record votes yes. Senator Kime. Senator Kime is absent. Senator Sanborn. Senator Sanborn is absent. Representative Sheehan. Representative Sheehan is absent. Representative Hagan. Representative Hagan is absent. Madam Chair, I have 9 members voting for the motion, 1 member voting against, and 4 members are absent.
Thank you very much. So the motion to table carries 9-1 with 4 absences. So we'll table the LD 1581 and close the work session on that legislation. And I see that there are some hands up. Go ahead, Representative Thorne.
Thank you, Madam Chair. I just wanted to thank Representative Babbage and Representative Co-Chair Harnett for their explanation. That helped a great deal with me. A lot of times I do have knee-jerk reactions to motions, and I don't fully understand being a freshman. And I certainly appreciate their efforts to convey that to me.
Thank you. Representative Moriarty?
Thank you, Madam Chair. If I'm out of order, I know that you'll immediately tell me so. In looking ahead to when this appears on our calendar next time, there are a couple of things that I would like to see. For example, I would like to have an opinion from the Attorney General's office. I would like to have an opinion from the Sheriff's organization and the Chief's organization. We're getting some anecdotal input, but I think it needs to come in through these organizations to meet the test that we typically ask of proponents and opponents of significant legislation.
Thank you, Representative. Okay, committee members, we will now move on with our next work session. And next on our list is LD 1774, an act well, actually, before we move on, I wanted to thank Senator Searway for being here today, helping us understand the bill better, and also for presenting the amendment. Thank you, Senator.
Thank you for your patience.
And thank you, Paul
Have a good day.
Rucha. And with that, we will open the work session on our next bill, LD 1774, an act clarifying the right to legal representation for individuals subject to guardianship. The sponsor is Co-Chair Harnett, so he's already on the panel. And at this point, we have been joined by our analyst, Janet Stocco, who is able to walk us through her bill analysis on this matter. Go ahead.
Hello, everyone. This is my first work session in the Judiciary Committee, so I beg your patience. In VLA, I generally screen share my bill analysis, so if that's okay with you, I would do that. Is that okay?
That's great. I think we'd all appreciate that. Thank you.
So this bill newly clarifies within the main probate code that an adult for whom a guardian has been appointed by the probate court nevertheless retains 2 rights. First, the right to retain an attorney for any reason. And second, the right to communicate freely with counsel, the court, an ombudsman, or any advocate for the adult subject to the guardianship. The bill also prohibits a person, which would include the guardian, from interfering with these rights. I do want to clear up a little confusion that might arise from the structure of the bill. So if you look at the bill here, can you see that? Okay, I'm always worried when I switch windows if the screen share will work. Sometimes it does and sometimes it doesn't. So in the bill, it looks like it's creating 3 rights, A, B, and C. A and B are actually in current law. You'll see that this is a repeal and replace amendment. And so what they've done is paragraphs A and B are already in subsection 2, and the bill just breaks them out so that they're 3 separate paragraphs and the language in C is new. So if you are worried about A and B and why I'm not talking about them in the bill analysis, that's because they are already current law. So I put a link here to the page where you can find the testimony and all the people who testified. All of the testimony was for, none against, or neither for nor against. Just as a little background, I know you all deal with the probate code a lot, so you might not need this background, but just in case, because there was a lot of discussion at the hearing about when do people have a right to attorney, what is clear in the law, what isn't clear in the law. I tried to give a little background here. So when there's an initial proceeding or a petition to appoint a guardian for an adult, the probate court always appoints a visitor who interviews the adult, informs the adult of their right to hire an attorney or request a court-appointed attorney. That visitor then submits a report to the court. I mean, the visitor does other things too. I'm just focusing on the attorney part. The visitor files a report with the court, and among other things that the visitor has to do is tell the court whether they think that an attorney should be appointed for that adult. Again, we're talking just at the initial stage about whether a guardian should be appointed. When the court decides whether to appoint an attorney, there is a statute requiring the court to appoint one. If the person who is going to be subject to a guardian potentially, that's called the respondent in statute. If they request, if the visitor recommends the appointment of an attorney, then the court will go ahead and appoint one, or the court could make its own determination that there needs to be an attorney and appoint one. Or if there's any suggestion that the respondent or the adult that might be subject to the guardian wants to contest the proceeding or limit the guardian's powers through the proceeding, then the court would appoint one. And then there are duties in the statute of the attorney who's appointed, including the right of the attorney for the respondent to attend any hearing on the petition. So that's the basis for the original petition and whether there will be an attorney involved. And then this statute here, 5-119, applies to all guardianship proceedings, whether it's an initial appointment or any later on proceeding in the case. It provides that, generally speaking, the respondent or the adult who might be subject to the guardianship, their assets are used to pay any attorney appointed to represent them, except if the court makes a finding that they're indigent, the court might itself pay. So the county probate court or the county finances would be used to pay that attorney. And that came up a little bit in the testimony about who's paying for these attorneys. So I thought you might want to see that statute. Then there was the focus of the bill is about the respondent or the adult who's now subject to a guardianship's right to communicate with an attorney and some others like the ombudsman or the court or an advocate. There is a specific statute already on the books that addresses the guardian's power to interfere with the right of the adult to communicate with others. So that's under section 5-315. And it provides that the guardian isn't allowed to restrict the adult's right to engage in communication with others, and there's nothing that limits that to not include an attorney. So generally speaking, the guardian can't limit communication rights, except under current law, there could be a court order specifically allowing the guardian to restrict communication rights. There could be some kind of protective order preventing some communication between the person under the guardianship and the person with whom they want to communicate. Or if the guardian has good cause to believe that they need to restrict this interaction, then they can go ahead and do so, and they have to provide notice to the court and some other individuals specified by law and the person who's under the guardianship that they're going to restrict this right of communication. And under current law, this communication provision doesn't apply to guardianships prior to September 1st, 2019, unless the court specifically says that it does. And there is a proposed amendment from Legal Services for the Elderly to eliminate this provision so that it would apply to every guardianship. As far as when does an adult who's subject to a guardianship, how do they get before the court their desire to maybe terminate the guardianship, remove the guardianship, modify it in some way, get a different guardian? There is statute governing that now. So under section 5-318, there's a procedure for removing a guardian and appointing a successor. So this is not a situation where you change the rights of the guardian or the duties of the guardian. This is just, we want a different person to be the guardian. And that can be initiated by a communication from the adult who's subject to the guardianship to the court. And there was some testimony that when an adult subject to a guardianship wants to communicate with the court about some problem they have with the guardianship, that they might want the assistance of an attorney. And I think that was part of the impetus for this bill. But right now, what it does say is that the adult subject to the guardianship can communicate with the court and say, you know, I would like maybe a different person to be my guardian. And then the statute goes on to say that if that adult is seeking to remove the guardian, then an attorney can be appointed by the court. It doesn't talk about the timing, and I don't know how the court would know to appoint an attorney before getting the communication from the adult, which I think was what some of the testimony at the hearing was about. As far as modification or termination of the guardianship, it's a similar process. Again, the statute provides that the person, sorry, my light always goes out. So if I wave my arms around, it's not because I'm upset at anybody. I'm trying to turn the light on and failing miserably. So as far as an adult subject to a guardianship seeking to modify or terminate the guardianship completely, they again can communicate to the court that they wish to modify or terminate the guardianship. And again, the statute says that the court can go ahead and appoint an attorney for them. But as the testimony at the hearing suggested, some of the proponents for this bill suggested there would be no way for the court to know ahead of time that the adult is seeking this, so there wouldn't be an attorney appointed beforehand to help the person subject to the guardianship go through this process. That's what the testimony is. I don't have any experience to know how it all actually works in real life. As far as a different statute that exists, and this is one, all the other statutes I've talked to you about are talking about adults subject to guardianship. This particular statute applies to both adults and minors. There is a separate statute specifying that the person subject to the guardianship can always file a grievance with the court if they have some problems with their guardian or even a conservator, and that the court has to look at the grievance, and specifically if the person is an adult, excuse me, this word here, who's subject to the guardianship, and there's a reasonable belief that there might be something that needs to happen, like as far as removing the guardian or terminating or modifying it. Again, this sort of echoes the statutes we just went through, that the court is supposed to go ahead and schedule a hearing and try and resolve that question in that situation. And if there's a hearing scheduled, again, those attorney appointment statutes would come into play, that the court could appoint an attorney in that situation. I do see a hand, and I don't know if your general process is to take questions during the bill analysis or after. I'm fine taking questions now. I defer to the chair.
Senator Keim, did you want to ask your question now, or would you be able to wait till the end of the analysis?
I can wait.
Okay, thanks.
So during the hearing, I alluded to this earlier. Leo Delicata from the Legal Services for the Elderly proposed keeping the parts of the bill that you see before you and adding another provision, which would eliminate the section of law that says that the rights of communication that the adult has and the limited ability of the guardian to curtail those communications. He proposed that you would eliminate the provision there that says that that law doesn't apply to guardianships established before September 1st, 2019. There was other information proposed during the testimony. So the Consumer Counsel Systems of Maine suggested that many of the adults subject to guardianship might not only need this proposed clearly expressed statutory right to consult with an attorney, but also access to free legal representation if they don't have any assets. I just wanted to point out to you that the bill, as it's drafted, doesn't talk about anything about payment by the county or anyone else for this attorney, or whether the attorney is free or not. It's just talking about clarifying the right of a person subject to a guardianship to consult with an attorney and communicate with the attorney or the others specified in the bill. The other thing I did want to point out is there was a lot of discussion during the testimony that someone who is subject to a guardianship, an adult, might want to consult with an attorney and talk about the possibility of maybe seeking a modification of that guardianship, but they are perhaps related to their guardian or friendly with their guardian, or for another reason, maybe potential of abuse by the guardian. Maybe they don't want the guardian to know that they're speaking to that attorney. And I did just want to point out that generally speaking, the guardian has the control of the adult's financial assets, and nothing in the bill talks about how the attorney is going to be paid without the guardian necessarily knowing. That may not be something that you want to address or solve in this bill. I just did want to point that out because it was something that was brought up during the testimony. I did also want to point out, if we look at the bill itself, the two rights that are already in law that are just being put in different paragraphs here are the right to vote and the right to marry. And it says, unless the court orders otherwise. This right to communicate with counsel and others does not say unless the court orders otherwise, which is fine, except that the current statute, sorry to scroll, I know that's hard to watch. The current statute about the right of a person subject to a guardianship to communicate with others does say unless the court orders otherwise. So it just may be helpful to clarify whether this right to communicate with an attorney is subject to court restriction or not. And that would be, you could either clarify it in 5315 or in the bill itself. I just did want to point out that that's slightly different language, and we could certainly clarify it with a committee amendment if you want me to do so. And then the last thing is I did set link here, so you can pull it up on your screens if you want, the rules of professional conduct that address the lawyer's responsibility when speaking with a client who may have diminished capacity. It does provide that generally speaking, the attorney is supposed to treat that person as a client who can make decisions as much as possible. But there are other provisions in there that talk about the fact that if the person who is the client does have a court-appointed person like a guardian, generally they're the person who makes the decisions. And I know Leo Delicata from the Legal Services for the Elderly is here today, and he can talk to you about that if that concerns you in any way. But I did just want you to know that when if you decided to go ahead with this legislation and authorize and make it clear that the person subject to guardianship can interact with an attorney, there are rules of professional conduct governing how that attorney will interact with the person subject to the guardianship. There was a request for the Office of Aging and Disability Services to be contacted to see how they felt about this bill. I do have a communication to me from Molly Bogart, who is the legislative liaison for DHHS, that they do not have any concerns with this bill. And they have sent Erin Salvo, who's the Associate Director of Adult Protective Services, to the work session in case you have any questions for her. And then there were also questions about whether this bill applies to minors, and it is drafted in a section of the probate code that just talks about adults subject to guardianship. And we could talk about that if you're interested. But if you think about it as an adult subject to a guardianship, it's the adult's own rights that are being curtailed through the guardianship. When it's a minor subject to a guardianship, it's the parents' rights that are being curtailed. And there are provisions in the law that govern minor guardianships about when a parent seeks to limit or terminate the guardianship and how they can get an attorney for representation. And even the court can appoint an attorney for the minor or a guardian litem. So there are just different processes that govern that situation.
Thank you very much, Janet, for the bill analysis. And Senator Keim, do you want to go ahead with your question?
Yes, thank you. My question was, just practically speaking, as you were going through the bill analysis, you're talking about how in current law, they can communicate to the court, the adult under guardianship can communicate to the court. And in a couple of places, you talked about them not being restricted from communication. But I was wondering, just practically speaking, if you knew or if someone could could explain to me how they go about doing that. Like, you know, are they, I guess it would just depend sort of on the, I guess what I'm asking is, depending on the severity of, you know, whatever their handicap is, does it actually keep them from communication? And so they have the right to, but how do we ensure, how are we currently ensuring that they have access, I guess is my question.
So the Veterans Legal Affairs Committee realizes that I am the legal nerd and I can tell you what the statutes say, but as far as how the real world works, I am not usually the person to ask. So I would defer to people who handle these cases on a regular basis.
So I guess just at some point, if someone else joins to discuss this type of thing, if they want to answer that question at that time, I don't need someone to come on at this moment, but I'm sure someone at some point could. Thank you.
And we will bring, I think a good place to start is with Leo Delicata, who's with Legal Services for the Elderly. And let me just ask Representative Harnett and Representative Poirier, are your questions pertaining to somebody who should be brought onto the panel, or are they for the analyst?
I just had a short statement. One, Representative Poirier at the public hearing had asked for me to reach out to Adult Protective Services. And as our analyst pointed out, we did so, and Erin Salvo is here to articulate the fact that they don't have concerns. As to the second question about from Senator Keim regarding what's it like in the real world, and I'm happy to have other people that are more affected in their lived experience talk about it, but we heard testimony over and over again about the difficulty of getting in the courthouse door because of the complicated paperwork that one might need to fill out without the assistance of an attorney. But we have advocates here and folks with lived experience that can probably articulate that much better than I am able to.
Representative Harnett, who would you suggest that we bring onto the panel to answer Senator Keim's question?
I would suspect Leo Delicata would have good experience in that area. And if he does not, I'm sure he knows who in the advocate community would.
Okay, thank you. And Representative Poirier, why don't you go ahead with your question? And I'm going to bring Leo Delicata over.
Thank you, Madam Chair. Just a couple of questions that I have that I believe the analyst may be able to answer for me. One of which is as far as curtailing any rights, as far as, you know, phone use, internet use, that sort of thing. There are systems already in place, even on a federal level and state level, where a person that is not able to, or is not being allowed to use such things as a phone and that sort of thing for one reason or another, a rights modification already needs to be reported. So I just wonder if there's any kind of redundancy in the wording of this law to what's already established. And then also, how is there a safeguard in this law if there is a person that is not able to have contact with somebody? Those are the people that I'm afraid are going to fall through the cracks. If they're not being allowed to use a phone or make contact with other people, those are the individuals that I assume this law is trying to protect. But just because the law is written on the books doesn't mean that the guardian is going to abide by it. So how are we going to ensure that this law is going to have the effect that we're looking for? Who's going to make sure that that's happening?
Well, I think your second question is a good one for which I do not have an answer. I don't know who would be enforcing this. Maybe Leo Delicata would know differently how that would be enforced. I mean, there are the rights on the books already. So in the law already, that the person subject to the guardianship can complain or file a grievance or put anything in writing to the court, whether they have access to the mail or to a telephone to actually make that complaint. I don't know, that's a good question. Who would be doing the checking to make sure that that actually happens? As far as your first question about potential redundancy, so the bill that's before you makes a clear statement with no restrictions that the person subject to the guardianship would have the right to freely communicate with counsel, the court, or any advocate or an ombudsman. And that is not subject to limitation by court order as written in the bill. The current law says that someone subject to a guardianship has the right to freely communicate with others, including in many different ways, social media, the telephone, or whatever, but that could be restricted by court order, or the guardian themselves could make a determination that because interaction with the person who the adult wants to speak to poses a risk of significant physical, psychological, or financial harm to the adult, that the guardian is going to curtail that communication. They are supposed to provide notice to the person subject to the guardianship, to the court, and others, like certain relatives, if they make that determination. So my question had been similar to yours. Is this right that's being proposed in the bill at all subject to limitation by court order? As written, it's not, which makes it a little bit in conflict with the current law. And I think it would be helpful to be clear whether the court can limit that right or not. And also, I do think it is clear from all of the testimony and the way the bill is written that it wouldn't be subject to a guardian's determination that, oh, well, I think it would not be good for the person subject to the guardianship to be able to communicate with an attorney. So I'm going to make that determination. I don't think that that is intended to be a limitation, which would otherwise be a limitation that exists under current law, if that makes sense.
Thank you for those questions, Representative Poirier, and also for your answers, Janet. At this point, we've been joined by Leo Delicata. And if you could please introduce yourself, even though I just said your name, and let us know what organization you're with. And I know you've been listening attentively to Senator Keim and Representative Poirier's questions. And if you could help us with answers, we'd appreciate it.
Thank you, Senator Carney. My name is Leo Delicata, and I'm an attorney with Legal Services for the Elderly. Senator Keim asked a great question, and that is, are there access issues? And I think that depending on the level of capacity that the individual has, those barriers are greater or lesser. With respect to filing a grievance, I guess it's pretty easy to pick up the phone if you have access to a phone, and if you have the ability to find the number, to call the probate court, talk with a clerk, and state what your problem is. I think that takes a good deal of organizational ability. So I think people would be challenged. Writing a note proposes the ability to actually have even more organizational ability to do that. I think Stacey Converse, who represents much younger people than we do with Disability Rights Maine, may have a perspective on this that differs a bit from mine. But yes, I do believe there are challenges. And if the individual is able to talk with family members or friends and express what problems they are having, then those people can assist in contacting the court. But the statute that you've been discussing with respect to a prohibition on the guardian's ability to interfere with those rights of communications it is something that I think presents a real barrier to most people, because it only applies to those guardians who were named prior to September 1st of 2019. And there are virtually thousands of guardians out there to whom that section of the probate code does not apply. So they can, they shouldn't, but they could restrict an individual's ability to communicate with anybody for any reason. And there's nothing in the probate code that says they can't, unless there's something in the judge's order that restricts their scope of authority. I'm very concerned about that. I mean, it would be good if this committee would amend that part of the statute so to make it apply to all the guardians, and there'd be something in the law that says you can't do this. But anyway, and I think that with respect to Representatives Poirier's comments and concerns about enforcement, I think there are, if you're in a, for instance, if you're in a nursing facility, there is federal law that makes it absolutely clear that you have the right to communicate, and that you have a bunch of other rights that that you haven't lost, and that facilities have the affirmative obligation to help you attain and maintain all of the abilities that you came in with. If you're not in a facility, if you're not in a controlled environment, if you're just sitting in your home and you have a guardian, I'm not sure exactly what the guardian's obligations are with respect to affirmatively making sure that you can continue to communicate with people. You know, the other issue with respect to guardians is that the reports that they are required to make are reports that the court orders. So if your guardianship order doesn't tell you that once a year you have to make a report to the court about how you have been helping or caring for the individual for whom you have responsibility, you don't even have to make a report. Now, I think that is changing. I think that after the, September 1st of 2019, when the new probate code was enacted and became effective, I think you'll see very few cases where there isn't an order saying you must report. But again, people prior to that time may be in a very difficult position of having a guardian who's done something that's restricted their rights, and especially their rights of communication, without anybody knowing it and without any reason for the court to know. And I think that's why this particular LD would really help. It would also help attorneys because, the Code of Professional Conduct has great language in it. If you have a client with diminished capacity, you're supposed to try to continue to represent that person and make sure that their values and their rights as they have expressed them to you over the years continue to be upheld. It doesn't really help us when somebody calls us and says, this is the problem that I'm having with my guardian, because they already have a guardian. And if they already have a guardian and the guardian has the ability to restrict their communications, for instance, or has restricted their communications, you have a difficult time establishing an attorney-client relationship with the person. And the Code of Professional Conduct basically says that if they have a guardian, ordinarily you have to deal with the guardian, because that means that the individual's decisional capacity is less. And the only time that you can proceed without really speaking with the guardian is if you reasonably believe that this individual is in danger of some physical or other harm. For instance, if they're being exploited and you think that that's really happening, and especially if it's their guardian, then it doesn't make any sense that you would have to deal with the guardian. If they want to terminate the guardianship, there's something in statute that basically says you can be represented by an attorney. So I don't have a problem with talking with somebody who calls and says, you know, I had a stroke, now I'm better, I don't need this guardianship anymore. But the rules of professional conduct are not so helpful when it comes to somebody who already has a guardian. So passing this particular LD, I think, would help in that circumstance also. It would clearly say that they have the right to communicate with an attorney for any reason. And so I hope I've answered the questions that have been raised, and if I haven't, I'm happy to try again. Thank you.
Thank you very much. That was a really thorough answer. And you mentioned Stacy Converse, and I would like to bring her onto the panel. I'm mindful that we are 6 minutes away from our break. So I'm going to bring Stacy Converse on and let her answer this series of questions as well. And we will have to take a recess and resume at approximately 12:15, but I think we can get started with hearing from her. And thank you very much, Leo Delicata, for your information. Welcome, Stacy Converse.
Thank you.
I know you've been listening. Would you like to weigh in as well?
Yeah, and I think Leo got most of it. I would just say, you know, in our experience in people trying to access the court system after they're subject to guardianship, there are serious obstacles to it. So frequently, if someone, you know, were to call the probate court, and it of course depends on which probate court you call, and say, you know, I want to terminate my guardianship, I have a problem with my guardian, they would receive a variety of answers of what to do, most often including filing a petition. I think, as we spoke to last time, filing something requesting an attorney and doing all of this paperwork on their own without an attorney and without anyone to advise them. And once they contact the court, that becomes part of the record that both the guardian and everyone else who's subject to notice has access to. So that is part of the problem. I think that this bill would really address. And I think, you know, Leo spoke to the rules of professional responsibility. The probate code also talks about how an attorney should represent an individuals who, I think they refer to it in the statute as a respondent, but the person subject to guardianship, and really lays out the duties of the attorney. And I think those were the major questions and thing I wanted to add to what Leo has already said.
Thank you very much. Committee members, any questions for, okay, go ahead, Representative Poirier.
Thank you, Madam Chair. Just real quickly, just because I work with individuals with disabilities, adults with intellectual disabilities on a daily basis in my day job. I just want to have your opinion. Do you feel like this bill is more catered to individuals that aren't receiving services elsewhere, that are kind of doing things on their own? The reason why I ask that is generally if a person is getting main care or any other services, they're going to have a case manager and perhaps a whole other team of people helping them with their services and organization. So they would have that support system to help them through something and be able to talk to them at least monthly, if not more frequently. So I'm just trying to gauge, is this bill more catered to, like I say, an individual who isn't getting that additional support and is trying to navigate the system on their own?
It's not. It's really for both groups of people. I would also say, you know, I think we work in the same worlds a little bit. I've been doing this for the last 13 years and work exclusively with people with intellectual disabilities and autism. Even if an individual has a fantastic case manager, and there are many, many, many out there, they also they're not lawyers. They can't, you know, they shouldn't be like giving legal advice. They really shouldn't be doing some of these things, and don't really have the technical ability. And I think, you know, a case manager, again, no matter how good they are, can advise an individual on whether they have a good case, right? Like, is this the time to bring the case? And so I think it's needed for both groups of individuals, but certainly people who don't have access to a support system, it would be even more important.
Right, the case manager should actually be having them get in touch with you.
Exactly. And lots of them do, I will say too.
Yes.
Thank you very much for the answers and the questions as well. At this point, we are going to take a 1-hour recess. And I don't think we need to, Representative Harnett, do you feel that we need to table this bill, or should we simply take a recess and resume at 12:15?
I would prefer to take a recess and resume.
Okay, so committee members and all of those who are in attendance for today's work sessions, we will resume at 12:15 or perhaps a few minutes before or after that, but we'll count on seeing everybody back at 1:15. Thank you.
12:15.
12:15, excuse me. Thank you, 12:15. All right, thanks, everyone.
Okay, thanks. Hey, Janet, can I ask an unrelated question?
Sure.
Has Senator Lucchini actually resigned?
He is a federal employee now, so he cannot be a state employee. I mean, a
Oh.
legislator.
Of course, yeah. I just wasn't sure if the resignation had taken place.
Yes.
I would like to have wished him well.
I don't think he went very far.
No? Is he going to be based in Augusta?
He just went down the block, right, to the post office building?
Oh, yeah. Okay.
I saw him the day he announced. He looked very happy. Everybody else looked very sad.
I can understand both of those things.
Yeah. Hi, Jim.
I'm reluctant to keep my microphone on because you never know when my dog's going to hear a squirrel and she goes right into bark mode sitting at my feet.
Always safer to keep your mic off. Sometimes I wish my mic was off when I was talking. But oh boy.
I just saw there were two Hall of Famers up north in the county that were fired for off mic comments, a hot mic, I should say.
I read that.
Oh, yes.
Last week.
Sports Hall of
Yep.
Famers.
That's right.
Dr. Fauci had some hot mic comments that were picked up recently too.
Yeah, he did.
It's going to have to be a new word for some Zoom liability. I don't know what Zoomability or something.
Tom,
Yes, Jeff. How are you?
I'm here, but I'm multitasking until I hear you start, and so I'm just going to be off screen, but I am here.
Okay.
Mr. Chair, a question, please.
Yes, Representative Newell.
Thank you. In looking at the Judiciary Committee testimony, am I to go to a different location to identify the testimony provided for and against, or neither for or against? The testimony that I see doesn't distinguish between those three.
I go to the committee materials and then look up the information by LD. And when you click on the LD number, it will list those who are speaking. And it says for, against, or neither for nor against, but it doesn't say so for the written testimony, at least where I look at it. You can't tell what
Okay.
side, what position.
That's helpful. Thank you.
It's a good question, because it would be easier, wouldn't it? And I know Senator Carney had an obligation in another committee, so we'll be waiting until, it's amazing how that works. Her picture just appeared. Good afternoon, Senator.
Hello, were you just talking about me? My ears were burning.
Yes, it was glowing. It was glowing.
You're too kind. I'm sorry that I was a little late getting back, everyone. Are we all ready to resume our work on?
Yes.
Okay, great. So we are on LD 1774, and we had heard from Leo Delicata and Stacy Converse regarding the benefits of the legislation and the role that it would play in helping provide access to counsel for those subject to guardianship. And let's see, Representative Harnett, did you want to weigh in on any of the information that has been presented to date?
I did, Senator Carney, and I think I will do so in the form of a motion, if I could speak to the motion, if that is okay.
That is okay. And again, not to cut off conversation or debate, but simply to focus our discussion. Go ahead, Representative.
I want to make a motion ought to pass as amended, with the amendment being the one suggested by Mr. Delicata, which would include the repeal of 18C MRS section 5, 315 parens 4. So it is clear that this provision applies to guardianships regardless of the time they were created. So it would apply to guardians appointed prior to September 1st, 2019. I did see in the chat a request from Kathy Ayers to address that, but I will leave that to the chair's discretion.
Yeah, thank you for pointing that out. So you've completed your motion, Representative Harnett?
I have, and for the reasons stated in the testimony that we've heard in the explanations, that's the basis for the ought to pass as amended motion.
Thank you. So it's an ought to pass as amended with repeal of the section that Leo Delicata mentioned. Is there a second? Representative Moriarty?
I second the motion.
Thank you very much. So we've had a motion and a second, and we have a panelist who I know has some important feedback to give us on that proposed amendment. And so I am going to bring her onto the panel to speak to that. And it will just take me a moment. Clerk Panett, could you please bring Kathleen Ayers over to the panel? I signed out and I lost my co-hosting powers. And it'll just take us a moment, everyone. Janet, do you also have co-hosting powers? Could you please bring Kathleen Ayers in as a panelist? Thank you. Kathleen Ayers, Register Ayers, thank you so much for offering to provide us some information about the proposed amendment. You can go ahead when you're ready.
Sure. I just wanted to briefly talk about how it's working now, because I hear Leo saying there's a problem and I don't see a problem. So I just wanted to talk to you a little bit about how it's working now. If it's brought to the court's attention, like if someone were to file a grievance on behalf of a person subject to guardianship, which is now the law, it would automatically go into a court proceeding, and we're following the current law. And also, most of the courts are doing an order and a letter and going back and making these people guardians do yearly reports. So I know we are going back and finding them, but it is a labor intensive thing, and we are finding some things. I mean, we are finding people who moved out of state, and it's a good reason. And I know a lot of the courts are currently doing that. I know Oxford's doing that because we don't want to lose it. We don't want to lose any, we don't want to someone to fall through the cracks. So that's how we're handling that. And I'll just stop there and speak to that amendment. I think, but we're all short-staffed. There's a pandemic going on. We have to get people out of the hospital and into nursing homes. And it's really, or out of nursing homes, or to say that it could be labor intensive for some courts like Cumberland, but when a problem happens, they do come to us, and then we're following this statute. You know, we're not saying don't come. This has not been a barrier to anybody that I know of. That's all I want to say.
Thank you. And there may be a question, Senator Kime. Did you have a question for Register Ayers? Go ahead.
Nice to see you, Ms. Ayers. So a couple of questions. I guess I need a little more clarification on from you, and I was actually hoping someone from probate would be here. Two questions. One is, do you see, if we did make this change, what kind of increase in workload that might be for the courts? And then I think I would like you to just talk a little bit more about you're not seeing this as a problem. Clarification in that you're saying you don't see people that want to have representation or have a change of guardianship or whatever. You don't see that they're somehow not able to get that.
Well, no, I'm seeing that we are following the current law, is what I'm saying, as far as that amendment goes. But yes, as far as attorneys go, you have to remember that I was trained by Jim Mitchell. So if someone writes something on a piece of toilet paper and is under guardianship or calls or has a problem, we are to take that seriously. We are to take that seriously. And if they have a problem, like my friend Julie, who does not like to be, who is a diabetic and doesn't like to have her medication, have her food restricted, we would get her an attorney immediately. I understand that perhaps that's not happening in some courts, but I do think that part of it is training and the lack of staff that has been going on with us and with a lot of people. But I do not see that as a problem. They are given attorneys. They also, it's restricted. The restriction on the guardian is in the order that they are allowed to communicate with whomever they want to. I was not here to oppose this bill, though, in any way. I mean, because to me, it's already in the statute. To me, it's already in the statute. It's there in a lot of places. And if it's not being done, then it's something that should be brought to the registrar's attention. If a clerk is answering the phone and someone says, I want to terminate my guardianship, and they say, well, you've got to go get the forms, then that needs to be brought to our attention so it can be fixed, because it is already in the law. And I understand that Stacy's Converse's position, she's dealing with younger disabled people. And I take it very seriously. And I think all the registrars do. And if they're not following the current law, then that needs to be brought to our attention so that it can be fixed, so it can be done in training, that, you have to take it seriously. I mean, I live in the land of AmHigh. I have been friends with people at AmHigh because of that. And I've also had death threats. And I've also had people that wrote a letter to the judge every week about, they wanted to be on the 5th floor of a facility so that aliens would not be able to get them. I mean, there has to be some limit somewhere. I mean, and we took those letters very seriously, though, and got him a new pair of glasses. Don't get me wrong, but when he wanted them, but I think it's already there. So, and if you can't restrict it at all, every time you call a lawyer, you're going to get billed. You're going to get billed, and somebody has to pay it. So in that respect, I do see that it would probably there is a potential for an increase in budget there. But like I said, I don't think any person should not have a lawyer. Please don't get me wrong on that. And the other thing is, it's in the order in the forms, the required forms. They're required. That means it's going to be a time lapse before we get the official forms. So if this does go through, there would need to be some work on that too. Because it is in the order for the guardian that they're not to read. All the restrictions that they have are in the order now. So I don't want to see, I just sometimes get a little upset, and you're going to have to forgive me when I hear people talking about a procedure and it's not what we're doing. That's not what we're doing. It's not what we're supposed to be doing. And yeah.
So you brought up another point. This bill would have an impact on the budget at the county level.
Yeah. Oh, yeah.
Mm-hmm.
If you're going to force us to go back, especially, and which we're already doing, but we're doing it not at all at once because we're busy. Then yeah, that would be something too.
So would it be an increase in budget for the extra lawyer fees, or would you also need increased staff?
There are a lot of counties that already need increased staff. So to put anything else on us is laborious.
So it would be both then. You think it could be increased lawyer fees and a burden on staff, likely not even, like everyone has a problem hiring. So I guess.
Yes. Yeah. I do. But like I said, as it's written now, they get an attorney, and they should get an attorney. And if they're not getting an attorney, that's a problem to me.
Mm-hmm. Thank you. I'll probably have another question, but I will think on this for a minute. Thank you.
And Representative Moriarty, you are next.
Thank you, Madam Chair. Ms. Ayers, I have a few questions for you. We've clarified already that the right to vote and the right to marry are in the statute. And they really, although they're part of the bill, they really don't need to be there because that's already in the statute. Leaving us with subparagraph C, which is the right to retain an attorney. So are you saying that that's in the law already?
That's everyone's right to retain an attorney.
Well, I mean, we say that, but if you're under guardianship, and I suppose that can be more or less flexible or rigid or whatever, but do you see any harm in saying that?
No, not in retaining attorney. No, I don't see any problem with retaining attorney.
Okay, so when you speak about increased legal fees, these aren't fees that the county would pay for, right?
Not in retaining, no.
Right. Well, and staffing burdens. Why would someone's right to retain an attorney impact your staffing needs or workload?
Well, I was talking about if we have to go back to all the guardianships before and do those all at once, which that's originally why it was there. And then we do court-appointed counsel too, though. We do court-appointed counsel. We pay for that, but yeah.
Well, my final question. Okay, but I guess I don't understand this idea of having to go back when we're simply creating the right of someone to personally retain and pay for an attorney. What do you have to
I was speaking to the amendment. Sorry. I was speaking to the amendment when I said that.
Oh,
On the going back.
What about the original statute? Do you have any?
I
issues?
originally didn't have any problem. I'm sorry. I cut you off. I'm sorry.
No, you didn't. You didn't. No.
I'm
Nope.
sorry. I think the original statute already gives them a right to have an attorney.
Can I just clarify, are you saying that you think the existing statute already gives them a right?
Yes. It's in all the states. I mean, in every place in
Yeah, it may be
termination, in original guardianship. It's
yeah,
it's already there.
I think there might be a misunderstanding about timing. So I'm going to call on the bill sponsor, and then Representative Poirier, I'll get to you in just a moment. Representative Harnett, go ahead.
Thank you, Madam Chair. What I was going to request is for Stacy Converse to be brought in to address the specific concerns raised by Register heirs.
Okay. And Representative Poirier, is your question also for Ms. Ayers?
I believe it is.
Okay, why don't you go ahead and ask that question, because it's going to take a moment for Stacy Converse to come through cyberspace to us. So go ahead.
My question was as far as going back and the sections in the bill, particularly that 2019 section there and such. My question is there a concern that having to go back into those was the guardianships prior to that time frame? Did they not have perhaps the maybe detailed information as far as who to report to, or who would have to have that written notification and such? And is that what would have to be gone back over in this process?
It's a lot of lost addresses because in the prior statute and with the prior judge, guardianships were given to families, and it was a family business. It was not after the guardianship was issued, you go, and if you have a problem, you come back. So that's how it was laid out in the former statute. And it is, I mean, we have gone back, and I know other registrars are trying to go back and find these people. Sometimes we are locating these people. We're not doing it. And maybe I'm misunderstanding the amendment completely. I mean, but I don't like, yeah, I'm really lost for words right now, so.
No, I thank you for that information. That's just what I was gathering as far as, having more workload that could potentially cause quite a bit more work if you had to find more information from cases that long ago.
It is. We really have a full plate, and so it does, yeah.
Thank you both. And we've been rejoined by Stacy Converse. And could you please speak to the benefits that would be attained as a result of the proposed amendment?
Sure, and I wanted to sort of clarify one thing. So I believe, so currently as written, it says that it only applies to current to guardianships going forward. And so I think some courts, including Kennebec County, from what I hear from Ms. Ayers, have gone back and told people who were put under guardianship years ago that telling their guardians that they have to comply with these new rights that are in statute. There is nothing in the proposed amendment that would require courts to notify folks, which I think is Ms. Ayers' concern. It would simply remove this provision, which quite frankly, I think both Leo and I would, say that it causes some great concerns about equal protection under the Constitution, as well as freedom of association, the way it's currently written. But it would just make sure that people's right to associate with others, they're not deprived of that right without notice and an opportunity to be heard. So, and I don't know if maybe there's some, I don't know if Ms. Ayers and I are sort of speaking past each other, which I hope we're not. And then I also just, if I could just briefly on the issue about the right to an attorney already being in the probate code, it's certainly in there once you're into the court system. So once you're in there, it's clear if you get over that hurdle to get into court, that if you want to contest any aspect of your guardianship, you should be appointed an attorney. So that is definitely in there. This bill really is about what happens before you get into probate court and really your access to representation before you're in the probate court, or your right to contact. We had Mikasa testified also about really people having an independent right to speak with an advocate.
Thank you. Ms. Ayers, you had raised your hand. Did you want to speak?
I just, you have this though, in this whole bill is in the order section of the probate code. It's in the order section. So this is what goes in this is going to be going in the order. So that's not before you get into court. So that's a little of my confusion, I guess, too.
Thank you for that comment.
Yeah.
Okay, we've got a couple of hands up. I'm gonna just call, okay, Senator Keim, you can go ahead but before you start speaking, let me just ask our analyst, Janet, if you could give us a little feedback in a moment about the concern that this is actually being located in the order part of the statute. If you don't mind helping us with that, and then we'll give you some time because I'm putting you on the spot. Senator Keim, go ahead with your question.
Thank you. So Ms. Converse, you mentioned that this was before someone was in court, but I thought they had to go through probate in order to be subject to a guardianship. So then it wouldn't. So this doesn't apply to. This only applies to people who are under guardianship, and therefore they have gone through the court. So I was confused by that statement, which I know Ms. Ayers sort of touched on, but I had to follow up because I also don't quite understand, and I thought you could explain that.
And I apologize, I really wasn't clear about that. So this statute is applying to people who are subject to guardianship. So they have gone through that whole process. The courts appointed them a guardian. It's really just the narrow window if someone who wants to terminate their guardianship has a problem with their guardian, if they want to retain an attorney, seek legal advice about contesting their guardianship, that they can do that before they're back in probate court so that they can get assistance to get into probate court.
Oh, okay, that I understand what you mean there, yes. And then would you foresee, so this is difficult, but if there are no limits, so is it always on the county to pay? Is it, if someone isn't of means and they want to fight their guardianship and they want to say, I want a different guardian or whatever, then it's on the county to pay for their lawyer? Is that right?
It's on the county to appoint a lawyer and pay for the lawyer.
Right,
so
right.
Once appointed, right? So
yes.
I'm not addressing the real difficulty of the lack of legal services in the state.
Right.
But
right,
people may have difficulty retaining an attorney that charges fees, right? Before getting back into court. So I would just say there's lots of legal service organizations like LEO, Disability Rights Maine, Pine Tree, who do these cases without charging fees to clients. So it would really impact those organizations and individuals who have the financial means to hire their own attorney.
Right. So you're saying they wouldn't have someone appointed until they made it into court. Okay. Okay, I understand. Yes, that makes sense. And then I guess I might want to ask the analyst if there's a way for us to get this looked at for an impact on cost to the county and have that looked at, because I am concerned that we definitely have that considered before this comes to a full vote. So I just didn't know if there's somebody we could run that by, because I think there's some questions around that. There isn't a definitive answer there.
I know that your question was directed to our analyst, Senator Keim. Having participated in the commission to bring the probate court judges into the state judicial branch, it's very hard to kind of wrap your arms around costs on those initially, because we don't, like, this would be conferring a new right on somebody to consult a counsel. And so we don't have any data to project the frequency with which it would come up in any specific county. I'm not saying we shouldn't try to do it, and we might have some kind of information that came up in the course of that commission that might be helpful. I also just wanted to briefly speak on the kind of the timing issue that you raised in your question. So in connection with a bill years ago that I had worked on, I did a lot of studying on financial exploitation of older Mainers, and often in a significant majority of the cases, the person who is committing the financial exploitation is a family member or friend, or is otherwise known to or potentially a guardian of an older person. And I personally could foresee this being a really helpful measure, because if somebody is under a guardianship and suspects that there's financial exploitation happening, this would give that person the right to consult with an attorney and have kind of a baseline understanding of what their rights are, and perhaps some kind of view of the evidence that led to that concern before they jump in and launch litigation. So I think that, I could foresee this being actually extraordinarily helpful to people who are subject to guardianship. So thank you for letting me share that experience. And Representative Moriarty, you're next. And we're not able to hear you, Representative.
Was muted by the host, according to a message I got a minute ago. Question for Stacey Converse. If the statute's amended to allow someone who's already in guardianship and has gone through all the procedures to get to that point, to allow that person at his or her own expense to retain an attorney, does that in fact impact county funding or the county budget or the allocation to the probate court from the county budget?
I'm so glad you asked that. I was also a little perplexed by that too. I don't see how it costs the probate courts anything more to have someone be able to retain counsel either out of their own budget or through free legal services. I don't see how that would possibly increase the cost to probate courts.
Okay, thank you.
Now I'm muted. Any other questions, committee members? Okay, so it looks like we've completed our questions for Register Heirs and Ms. Converse. Oh, we may have another question. Go ahead, Representative Poirier.
Thank you, Madam Chair. It's more of a comment than a question.
Let me just, I'm going to send them off the panel, and then you can be the first one to launch us into our discussion of the bill. So give me just one moment. And thank you both very much for your feedback today. Okay, go ahead, Representative.
Thank you very much. I know the bill is very well intentioned, and I definitely am an advocate for the retention of rights, especially for those with disabilities. One thing that we have to remember, though, is just because a person is under guardianship does not mean they lose their rights. They still have the same rights as you and I do, even if they're under guardianship. Something that we do need to think about perhaps in later legislation that we can work on as a committee is actually getting to the resolution of the problem we're trying to solve. The people that we're trying to help aren't aware of the resources that are available to them. This law is not going to make them aware of those resources. Hopefully it might navigate the system a little easier for them, but we really need to work at getting the contact information out to individuals at maybe perhaps younger ages, in school age, letting them know what resources and rights they do have and what's available to them, so that they know when a guardianship comes into play, who to go to, who they can turn to if this scenario were to happen. I think that is a better resolution than trying to fix something after a problem occurs. So just something to think about. Thank you.
Thank you. Thank you. Janet? Were you waving your hand?
I'm just trying to remember all the questions you asked me, and I'm afraid the longer you talk, the more I'll forget them.
Okay. You have the virtual floor.
About the cost to the county, I agree with you. It would be difficult to know who to ask. I will just say that I think I read the bill the same way Ms. Converse does, and I might not understand the way that Kathy Ayers is reading it. So maybe that means it could be clarified. But as I understand it right now, if you are under a guardianship, you communicate with the court under all the statutes we went through before and people have talked about. It sounds like in Kennebec County right away, they'll think about appointing you an attorney if you don't have one, and making sure you get into court. In other courts, they may read the law a little more literally and examine whether there's reasonable grounds, but there is this process to get back into court and maybe get an attorney appointed. The bill as it is written just talks about the fact that you, despite the fact that you have a guardianship on you, which means that you don't have the right to enter contracts and do all of the other things and make your own decisions, the bill would say, even though all those limitations occur, even though the main rules of professional responsibility say ordinarily, if you're under a guardianship, the attorney has to do what the guardian says, this bill would say, nope, the fact that you're under a guardianship does not get rid of your right to consult attorneys or advocates for your own purposes. It doesn't limit it to being about the guardianship or anything else. It just says you have this right to consult an attorney. It's sort of this freestanding independent thing, whereas all the rights about attorneys in the probate code now are about your rights to attorneys in probate court proceedings that have already started in some format. So I think that's what the advocates are saying is the reason they want to add this to the bill. I don't know, I think I read it the same way that they read it, which is that it doesn't force a court to pay for that attorney, because this is not a court-appointed attorney with a finding of indigency for which the county would then be on the hook under the statute to pay for that attorney. This is the person under guardianship going out and communicating with an attorney on their own, if that makes sense. So directly, I don't think it costs. Where it may cause a cost is if more people under guardianship realize they have this right and they're afraid now to seek petitions to modify their guardianship or to terminate it. And they're afraid to now because the guardian might find out. And if this were publicly disseminated, if this were enacted and that right was known better, then perhaps more people would then seek the advice of an attorney, and they would realize they could go to court and they would have the help of an attorney in doing so. And later on, there might be a finding of indigency. So there may be more of these petitions to modify that eventually hit the probate courts. And in that sense, I could see an increased cost if a lot of those people or some of those people had a need for free counsel, if that makes sense. But the freeness, it doesn't happen up front, at least not the way I see it drafted. The other question you asked me was about where it is located. And I think it is interesting that it is located in the section of statute that talks about the contents of the court order. And if I could share the statute with you for a second, I could maybe explain what I didn't very artfully explain the first time around in the bill analysis. This is that statute that's currently here, the order of appointment, and it talks about what the order has to include, the findings for the appointment of the guardian, and then it also talks about the rights retained. And I believe this is in the statute. I wasn't here when you did the probate code, so you all know this better than me if you were on the committee when that happened. But I believe this part, which is paragraphs A and B of the bill, because they're already current law, I think this is in here because it's telling the court, reminding the court, they have the right to vote despite the guardianship unless the court orders otherwise. So it makes sense to put this in the court order provision to say, hey, court, you could order otherwise. So that would be in the order. There's also the right to marry unless the court orders otherwise. So court, if you want to limit that, you have to put that limitation right in the order and you have to make the findings that are declared here. In the bill, this third right that's being added, this is the only new part, is paragraph C. It doesn't seem to be subject to a limitation by the court. So maybe this isn't the right place to put it because it's not about the court order. This is about this freestanding other right that despite the fact that you're under a guardianship and ordinarily somebody might think you don't have the right to go out and retain an attorney, this bill would say, yes, you do. You can go consult with an attorney, you can consult with an advocate. And that isn't, it doesn't have to be ordered by the court to be true because this bill is saying it is true anyway, if that makes any sense. So I don't know that it has to be in the court order. I think, and I can't really speak for Kathy Ayers, but it sounds like her court is very careful and wants to make sure everybody knows the implications of what is happening. So either it's a court, most of the probate court forms are statewide. So either she is thinking that the statewide court form that is used when a guardianship is created will have to be modified to make sure that this right is really clear so everybody knows, in which case that's a cost to change a form. And that could be a significant cost. I honestly don't know. I haven't had to change a court form across all the counties. Or she's thinking that we want to make sure everybody knows, so we will add it to our form as what, even if it's not on the standard form. So you were asking about the location. I think it's fine to be where it is because it's saying, by the way, the court order isn't limiting this right. It's just, it doesn't have to be there. It could be somewhere else. I don't know if I'm answering your question correctly, but those are the questions I wrote down that you asked.
That was very helpful. Thank you. And I guess I have a question for the bill sponsor, which is, do you think it is appropriate to add to this section regarding consulting with the council the same language unless the court orders otherwise?
That was not my intention in submitting it, no. But I think that that is a right that should be free from interference.
Do you think that it should be, the bill should be amended to relocate this paragraph and this articulation of that right to another section of the probate code?
I'm not a probate expert by any means in terms of answering that question. I did hear our analysts say that it is appropriate in the section that it is in because it's stating a pre-existing, a freestanding right.
Mm-hmm. Thank you. I wanted to run those by you. I agree with you, but I thought that those were important questions for us to cover as a committee. Thank you.
Thank you.
Committee members, any additional discussion? We have gone over a lot of information about this bill, and I would like to know if the committee is ready to move to a vote on the motion, which is an ought to pass as amended. Go ahead, Senator Keim.
Thank you. Yes, I don't have an answer to that question, but I would like to do a quarter caucus.
Okay. All right, so I think that that's a great idea. And so it's 1 o'clock now. Senator Keim, if you had 10 minutes, would that be sufficient time for a quarter caucus?
Uh-huh, plenty.
Okay. All right, so let's take a brief recess until 1:10, everyone. Representative Evangelos, did you have a question?
Yes, Madam Chair, I'm going to go to the dentist and have a tooth pulled.
Oh, I'm sorry.
No, I'm kidding. Submit it without comment.
Okay. All right, it looks like most of us are back, and let me just see if there are any committee members who have not rejoined us yet. Representative Evangelos's hand is up, and I think, oh, great, Representative Brackett. Okay, Representative Evangelos, go ahead.
Residual hand, take it down.
Thank you. All right, thank you, everyone. Representative Harnett, go ahead.
Thank you, Madam Chair. I would like to move the question and speak very briefly in support of my original motion. First of all, I have a great deal of respect for Register Ayers. I always have, and I believe that she operates what is the gold standard when it comes to probate matters. But the reason I put this bill in was I heard from advocates that is not the experience of their clients in courts throughout the state of Maine. And we also heard what I found to be rather compelling testimony from individuals subject to guardianship about the difficulties and challenges that they face when they are trying to modify a guardianship order that they are living under, an order that can have severe restrictions on their day-to-day liberties. What this bill is designed to do, and I think it does, and I think that was supported by the explanation of our analyst, is it allows people to get through the courthouse doors. It allows people who are subject to a guardianship to consult with an advocate, to retain their own attorney, to seek the legal services provided for free by agencies like Legal Services for the Elderly, Disability Rights Maine, Maine CASA, in the event that they are subject to sexual exploitation, etc. Those all come with no cost to the county. I would also point out that this committee will be seeing a report from the commission that studied probate that will recommend the transfer of the costs for court-appointed attorneys, and that's not what we're talking about in this bill, but for court-appointed attorneys to no longer be borne by the counties, but to be funded through the MCILS system. So I think it's attenuated at best to look at this bill and say, well, if A, B, C, D, E, and F occur, there might be a cost to the county. This is about getting into the courthouse door or seeking out and speaking to an advocate if you're the subject of exploitation. So I would ask committee members to please support the ought to pass as amended motion. Thank you.
Thank you, Representative Harnett. Is any other comments? The committee ready for the vote? Representative Babbage? Actually, let me just, we had a Representative Harnett moved the question. Representative Babbage, are you raising your hand to second
I'd
that?
be willing to second as well, but I would like to speak to the motion.
Go ahead and speak to the motion.
Thank you very much. You know, I'm looking at this as the, I guess, as the moral universe bending toward justice. Constitutional rights should not be abridged without great care. And in this case, I really feel that we're taking a major step forward. So that's why I'll be voting in favor of the motion. Thank you.
Thank you. Any other discussion? I'm not seeing any. Clerk Panett, I think we are ready for the vote.
Thank you, Madam Chair.
Thank you.
Representative Galgay-Reckett.
Yes.
Thank you. Representative Galgay-Reckett votes yes. Representative Newell.
Yes.
Representative Newell votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Senator Keim.
Yes.
Senator Keim votes yes. Senator Sanborn. Senator Carney.
Yes.
Senator Carney votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Thorne.
Nay.
Representative Thorne votes no. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Hagan. Representative Libby.
Yes.
Representative Libby votes yes. I'll recall the absentees. Senator Sanborn. Senator Sanborn is absent. Representative Hagan. Representative Hagan is absent. Madam Chair, I have 11 members. Excuse me, 11 members voting in the affirmative for the motion, 1 member voting against, and 2 members are absent.
Thank you very much, Ms. Panett. And the ought to pass as amended motion on LD 1774 passes 11-1 with 3 absences. Our colleagues will have an opportunity to vote over the next 48 hours. And I see that our analyst has her hand raised. Go ahead.
I just want to confirm Representative Thorne's report.
Representative Thorne, what is your
ought not to pass?
Nay.
Right, you didn't support the ought to pass as amended, but are you ought not to pass or straight ought to pass or a different amendment?
Oh, I'm sorry. Ought not to pass.
Thank you.
Thank you both for that clarification. And with that, we'll conclude the work session on LD 1774 and move into our next work session. And that is on LD 1804, unless Peggy, has something scheduling happened while we've been busy with our other work? Are we good to proceed with 1804?
I think you're good to proceed. I don't know of anything else happening.
Okay, wonderful. Thank you. And I'll see if the bill sponsor is here and ask her to join the panel. And do you have I know you do have a bill analysis. That's a silly question. Would you like to present the bill analysis, please?
Sure. I know that Janet shared hers. Is that helpful to you? Hers is much more detailed than what I do, but I'm happy to share it if that's helpful.
Let's poll the committee members. If you would like Peggy to screen share the analysis, raise your hand. And if even one of us wants that, we will do it for everybody. So I am not seeing hands raised,
Okay.
Peggy.
Well, I don't think this is quite as complicated as the bill that you just handled. It's longer, but it's not as complicated. LD 1804 is an act to provide consistency in the laws regarding domestic partners. And what the bill does is use the probate code definition of domestic partner, which means a domestic partner means one of 2 unmarried adults who are domiciled together under long-term arrangements that evidence a commitment to remain responsible indefinitely for each other's welfare. So that's the definition in the probate code currently for domestic partner. The bill takes that definition and puts it in Title I. There's a section that's called words and phrases, and they're general definitions that apply throughout the statutes. That's section 1 of the bill. And then the rest of the bill goes through and deletes any other definitions of domestic partner. And where necessary, it cross-references this provision in this new provision in Title I. So there are slightly different versions of what it means to be a domestic partner in the statute in order to be able to take advantage of certain procedures or insurance benefits. This would make the general definition apply in all those situations. There is some confusion now where the definition works in one statute and it doesn't work in another. There is a domestic partner registry, and domestic partners who register, it's administered by the Department of Health and Human Services. And when the vital statistics, once partners register, they become registered domestic partners. And that is a different level of legal recognition right now. It was created before marriage equality. And so this was a way for whether they were same sex or different sex partners to have their relationship recognized. Still requirements of what they needed to show in order to be registered. And if you have the bill analysis, I did include that. It starts on page 4 of the bill analysis, what they have to show. So that's registered domestic partner right now. The probate code recognizes registered domestic partners at the same level as a spouse. You can't have a spouse and a domestic partner at the same time. So anywhere the probate code provides benefits or rights or requirements for a spouse, that by definition applies to a registered domestic partner. We've looked, and it looks like the only other governmental entity in Maine that has its own registry that we could find, we've talked with Maine Municipal Association and other folks that we thought would know, is the city of Portland. They have their own domestic partner registry. And again, that predates what was in the state, and that was in order for the city to provide benefits for domestic partners. If they were registered under the city's registered registry, then they would be able to access benefits for registered partners in Portland. I understand there are some other governmental entities that recognize domestic partners through ordinances to provide those benefits, but without requiring a registry. There was testimony in favor of the bill, trying to recognizing some of the confusion. Nobody testified against, but there were several folks that testified neither for nor against, pointing out that if the definition is not completely clear, that means everybody who has to apply it is going to have to interpret themselves. Insurance companies were the most concerned because right now the statute requires mandated benefits in different types of insurance for domestic partners, and the insurance code defines what it means to be a domestic partner, including a 12-month duration of that relationship, at least a 12-month duration. So I think the question that was raised by the people who testified neither for nor against was what do those words mean about long-term arrangements that evidence a commitment to remain responsible indefinitely for each other's welfare. The concern was that each entity in applying the law, whether it's insurance law or the Uniform Anatomical Gift Act or the advanced healthcare decisions, so who makes a decision when somebody doesn't have a living will, they'd be left to kind of figure out what that language means, and perhaps they might fall back on the old definitions, or they rely on the registry, even though the statute doesn't provide that. So I think one of the questions was, how do you identify that a domestic partner relationship works? And we can talk about maybe different options to address that if you have questions.
I see that Representative Reckitt has her hand up, and I know that Representative Roberts is trying to join this meeting, but I don't think she has her link. And so I guess I'll ask our committee clerk if Ms. Panett, could you please send Representative Roberts her link again so that she can join us? Thank you.
Happy to. Thank you.
Thanks. And Representative Reckitt, you had your hand up. Go ahead.
I think / hope I have a simple question. My wife and I were registered domestic partners about, I'm not sure how many years ago. She's not home, can't overhear that I can't remember, so don't report me. But the point is, we were registered domestic partners for quite a long time, and then we were able to marry, and we did. So, we've been married for 10 years. So my question is, or almost 10 years. My question is, where is that old registry, and are they taking people out of that when there's any kind of cross check, or should we tell them that we got married and pull us off your list, or do we care?
That's a good question. I'm not sure, because your marriage somewhere goes through vital statistics. Perhaps there's somebody there who is double checking and taking them off. I know that if there were registered domestic partners whose relationship did dissolve, that they are expected to notify the registry that they no longer are domestic partners, and so that can be removed.
Well, I think I'll just not worry about it.
Thank you, Representative Reckitt. Representative Thorne, go ahead.
Thank you, Madam Chair. Peggy, I don't know if you can answer this or not, or somebody can. It used to be common law spouse, and I don't think Maine did they ever recognize that?
Not legally, no.
Okay, so for those of us over the age of 30, did domestic partner take the place of that term? And there's unregistered domestic partner and there's registered domestic partner. Is that right? And there's city level like Portland, and then there's county or state level registered.
Right. My understanding is there's the state level registered partner, state level domestic partner registry. And that was put into place in order to provide legal recognition of people who weren't married but were in a committed relationship. So that was a legal recognition. There was a lot of discussion when that went into place. I think it was in 2003, about people who were in a relationship but didn't execute wills. So when one of them died, there was no legal right to anything of the estate. And the response to that was this registered, if you don't have a will, but you are a registered domestic partner, the probate code recognizes you at the same level as a spouse. So you have the same rights that a spouse would have if you went through the process of registering as a domestic partner. This bill doesn't change any of those requirements. And I'm not sure I'm answering your question about it. Has domestic partner taken the place of common law spouse? Because Maine never actually legally recognized common law marriage. If somebody can show that they are in the relationship that meets this definition, then I suppose that is the situation. But in order for inheritance, they do have to be registered, my understanding is.
Yeah, okay. I'm trying to understand the terminology and whether or not, those swords ever cross where, common law and domestic partner intersect. So thank you.
We have been joined by the bill sponsor. We're glad that you were able to join us, and we just wanted to give you an opportunity to speak to the bill analysis and update us in any way regarding the bill before I move on and call on other members of the committee.
Thank you, Madam Chair. I think in this case, I'm going to defer to Ms. Bonato, since she has more expertise in the subject of the bill. And to your analyst, this is not my area of forte. I just saw the need for a cleanup, and however the committee sees fit to do that would be greatly appreciated.
Thank you. And are you, okay, so we'll bring Mary Bonato onto the panel in just a moment. Thank you. Senator Keim, go ahead.
Thank you. I appreciate the idea of trying to make things concise and easily understood across all areas of law. So I appreciate the idea of creating one definition. And one of the things I was hoping that you could help me understand the implications of, Peggy, is the idea of just putting it in law that a domestic partner is someone who is registered. I feel that we have all these different ways that we're putting the responsibility on people to consider whether or not somebody is, you should be legally recognized. And I think if we want a legal construct around a relationship, I think it's very fair to say, well, just register. I mean, I did look at the website. It does seem pretty easy to do and puts the responsibility on folks to just make that decision. Then we're not looking at, well, how many years have you been together? Or I don't know, it just seems really awkward in a lot of different situations that we heard about at the public hearing. And so I wanted you to walk me through, because I did look through, the different areas that we were looking at in law. But the implication of saying, okay, if you're registered, you are, and if you're not registered, you're not, that part is beyond me. I wouldn't know. So I didn't know if you could help me understand that, Peggy, a little more, what that might look like.
Right. I think it's possible to do that, to go through the statute and every place where it says domestic partner, amend it to say registered domestic partner. I think that's a significant change in the laws. Right now, in most situations, the law does not require the partners to go through that registration process, where it talks about domestic partners. So that would be a change from a drafting or a law perspective. Maybe law is not the right word, but writing a bill, we know how to do that, and that wouldn't be that difficult. I think it's a significant change to the people who right now receive benefits as domestic partners who are not registered. They haven't gone through the registration process, but they're still recognized as domestic partners because they meet whatever definition applies in those situations. I'm not sure if I'm answering your question. I see there are two significant aspects to that. One is, how do you do it? And the other is, what is the effect? And the effect is definitely a policy question that the legislature would have to address.
Okay, that's helpful. Thank you.
Thank you, Senator Keim. And we've also been joined by Mary Bonato, who the bill sponsor asked us to bring on to update us on any additional information or discussions about the legislation. Welcome. We're not able to hear you. Thanks.
Thank you very much. I actually wasn't expected to be called on this, but I'm here listening anyway. With respect to any updating, I think I would say that when it comes to the insurance code, there is already a provision that was not amended by this bill that allows for an inquiry into the bona fides of the relationship. And likewise, hospitals would be able to rely on that as well. So I think that's at least an answer to some of the concerns that were raised at the public hearing. That said, the issues raised at the public hearing extended further to whether within entities or fields or industries, there could be different standards. And this is a bill that's really intended to harmonize standards. So it would be valuable to have some more time to try to address that issue. You know, if that really is a concern, there are certainly a number of potential solutions to that. But, you know, there are certainly people, including the sponsor, who need to weigh in on those things.
Thank you for providing that information. And thank you for being here, even though you were not expected to be moved to the panel. And I'm going to send you back to the attendee space and call on Representative Libby, who has a question.
I do, and it may be of value to keep Mary here for a bit. I'm not sure that the sponsor will be able to answer this question, but perhaps Peggy will be if Mary's still not here. So my question would be, I come at this bill from a longtime career as a bedside nurse, and in the ICU, we would frequently, very frequently, deal with a scenario where you're dealing with end-of-life issues. And forgive me if you did deal with this and I missed it when I caught up on the public hearing, but that's a scenario where you often deal with this issue of the domestic partner question. And I don't see this clarifying anything there. So I just am wondering, in this very practical scenario, we would generally face, you have someone claiming that they're a domestic partner, they're not registered, they've been with their significant other for X years, but there's nothing official. And they do or don't want to pull the plug. And then the person who is ill, their child, does or does not want to pull the plug, and they disagree with the purported domestic partner. And there's always someone having to get involved to, you always have courts involved or something before anyone can make a decision there. I have to agree with Senator Keim. It does seem like a much simpler solution is to simply say, if you want to be called domestic partner, register as a domestic partner, and then we can stop having that question. And the other thing that I would bring up is, am I understanding correctly that this is a brand new bill and not a carryover? To my mind, I simply don't see the emergency in it, which is the other problem I have with this bill. But if someone could give me some clarity on how this clears up the very practical solutions that medical staff deal with in a hospital on an everyday basis, that would be great.
I'm not sure if I'm the one to do that, but I've pulled up the Uniform Healthcare Decisions Act, which allows, it lays out the process for a surrogate, somebody, when the patient can no longer make decisions or is in a situation where the patient cannot make decisions and has not executed some kind of either a healthcare power of attorney or a living will that says, here's what I want to happen when I'm in a situation I can't make my own decisions. I'm going to share the screen, if that's okay.
Mm-hmm.
So this is the priority of who may act as a surrogate. First is a spouse. The next is an adult who shares an emotional, physical, and financial relationship with the patient, similar to that of a spouse. What is not here is actually using the term domestic partner. So I think I misspoke when I said that this was part of that the this bill amended the Healthcare Decisions Act.
Okay.
So hospitals, doctors, nurses, healthcare providers are already dealing with this language about an adult who shares an emotional, physical, and financial relationship with a patient similar to that of a spouse.
So this does not amend that, Peggy?
This
is dealing with other areas of statute. Okay. All right.
So it does amend other areas, but not this. And I'm trying to think if it amends the Uniform Anatomical Gift Act. And I will double check that, but it does not amend the Healthcare Decisions Act. That, I mean, there is that there's that weighing that the healthcare provider has to go through when there's no spouse, there's an adult who says, I'm their partner, or I have this special relationship with the patient, and there's an adult child who you'll see is the next level down in the hierarchy, who disagrees with the decision. That's always something that the healthcare providers are dealing with now.
Right.
This doesn't change that.
Okay,
And-
thank you.
And Representative Libby, Mary Bonato is able to rejoin the panel. And so let me just look around, and I think that she'll be able to provide an answer to you as well. Maybe I did not effectively accomplish the transfer. Oh, thank you for rejoining us. Were you able to hear Representative Libby's question?
No, I was not. I'm sorry.
Representative Libby, could you restate your question?
Yeah, the first piece is apparently moot, because if Peggy is saying that it does not affect the healthcare piece, then that is moot. I agree with Senator Keim. I'm having a difficult time wrapping my head around why we need to make changes to be uniform rather than simply a domestic partner, register to be a domestic partner if you want to be a domestic partner, and then it's clearly delineated and no one has to guess at what long-term arrangements that evidence a commitment to remain responsible indefinitely for each other's welfare actually means. I'm sorry, Mary, I amended my question because Peggy clarified that it's not going to affect the area that I had been under the understanding that it was going to.
Well, just very briefly, a reason to consider, or at least to really move in the direction of some sort of standard, is because then not only lawmakers, but everyone else has a sense of what the law is. And so if you take, for example, the issue of protection from abuse orders, it's going to put domestic partner in there in a way that doesn't require that you've technically registered with the registry and you've paid the fee and you've done the paperwork. And as somebody who long ago did some estate planning and things like that, I will tell you that the vast majority of people do not do estate planning, do not fill out these documents, and sometimes go to lawyers who do not even know all the documents that ideally they would execute. So that's just one thing that I would say, is that it will help actually effectuate some of the purposes of the statutes that you have to make sure that they cover people who really should be covered because they are in the kind of relationship that the probate court describes. When I testified last time, it was like pointing out just ethics rules, for legislators and lobbyists, and disclosures where you want to make sure you're hearing from people, and that with, having a definition like this means that you get cut into rights and you also have responsibilities. And the registry, I was explaining, at least from my experience in the state throughout this time, was really initially not all that protective in terms of providing any kind of protections at all, but that it was in part symbolic to say, yeah, we are family. We've got this now from the state, a piece of paper that says we're registered domestic partners. But what happened over time was that as people became more comfortable with this concept and with the idea, not only of same-sex couples, but of different sex couples who form families and make real commitments to one another and to raising children outside of marriage, that it wouldn't be good public policy just to say the only dividing line is marriage. You're either in it, you're either in marriage or out of everything. And so I think that's another aspect of what's been going on here over the years. And then when it comes just finally with respect to insurance, it was the insurance codes that were first amended in 2001. And that was really, again, because I recall from the time, really clamoring from employers who were very frustrated that they could not extend to their employees a family policy of health insurance, no matter how long those employees had been with their partners and raising kids, but they had to buy multiple policies, which everyone knows that's hard enough to buy one, let alone multiple policies. And so that the insurance code has never required registration, but it has required the 12 months. And again, you may make some policy decisions around that, but there is a sense that, you can marry or get divorced and put somebody, remarry and put somebody on your policy the next day. if you're married, and is 12 months really the right standard or a fair standard? And again, I gave some examples from before about how requiring the 12 months really leaves some people out who, as a matter of both responsibilities and rights, should likely be cut in. Or at least you can make that argument. Thank you.
Thank you. Any follow-up, Representative Libby?
No, just to note that I still fail to see the emergency.
Okay, thank you. And Representative Moriarty, go ahead. And Mary Benado, are you okay staying on the panel for a few more moments in case we have additional?
Yeah,
thank you.
Thank you.
Okay, go ahead, Representative Moriarty.
Thank you, Madam Chair. My list of questions has grown a little bit, but I'll just ask two at this point, if I may. We have correspondence from Peter Gore of the Chamber of Commerce, and he, among other things, indicated that there was a committee known as the Commission to Study Establishing Paid Family Medical Leave in Maine. I was not aware of the existence of this commission, but to either Peggy or Mary, do you know if this commission has reported, and if there's legislation in the second session that reflects their work product?
I know that my office was staffing that study, and I was not one of the staff people, and I'm going to look to see if I can see if their report is complete.
And I would just say, I think that's a question that deserves some follow-up.
Mm-hmm.
I'm not seeing their report, but hold on.
Apparently in the public hearing, somebody mentioned that they should be allowed to complete their work. So I think the last line that is under people testifying in your analysis, people testifying neither for nor against, the very last piece makes one think that it's in progress.
Right, I think they last met on January 10th, and there is, I can put their website in the chat. But I think what Mr. Gore was saying is one of the recommendations is to get some more actuarial information. And so his thought is, if you change the statute, the actuarial study is going to be looking at something that's no longer law. I don't know if that's already in process, the actuarial piece of it.
Okay.
Yeah,
maybe.
Representative Moriarty, I'm sorry to interrupt you, but Peter
Sure.
Gore is here as an attendee. We'd like to bring him over to the panel and just have him confirm that that is his position. And I'm also beginning to think that we should consider tabling this bill so that we can do a lot more work on these issues before we move to a vote. That's just kind of what I'm feeling at this point, but okay. And he has joined us. Peter Gore, thank you for joining the Judiciary Committee. It's nice to see you. And did you want to comment on the paid family medical leave study? Give us some insight.
Yes, thank you, Senator Carney, and thank you, committee members. I have been following you this morning, this afternoon. You've had a busy day today, so I won't belabor this. So the commission has met at least 4 or 5 times, and since this fall, and the Senate chair is Senator Daughtry, and the House chair is Representative Cloutier. And they are made up of a variety of different appointees by the Speaker and the President to take a look at the establishment of paid family medical leave. And, obviously you could ask one of the 2 legislative members to update you further, but they have been working, gathering information, talking with other states that have established a paid family medical leave program, and taking comments from stakeholders, including the chamber and others. And at this point, I think it's fair to characterize them as they are starting to put together what their package would look like, that they would then request an actuarial review of, to get an idea of, who's going to be covered, how much leave is going to be offered, for how long, and to pay how much. I spend a lot of my time in the workers' comp world, and some of you are also familiar with it. So, setting up an insurance company, which is essentially what this is a complicated matter. I believe at the last meeting, the Senate chair indicated that they would not be completing their work this session, and there would not be a bill for the legislature to consider during this legislative session. I believe the process they're in when it comes to talking with actuaries is they have taken information from actuaries inside the state and outside the state, some of whom have been involved with establishing paid family medical leave programs in other states. I don't believe they've chosen anybody in particular at this point. That's still part of the process they're in. That's what I know. I follow them. I attend all their meetings. And so it's a pretty objective overview of where they are at this present time. I hope that's helpful.
That's very helpful. Thank
Yes,
you.
yes, very much so.
I think you answered the question. I'm going to move you back to the attendee part of the meeting.
Thank you very much.
And Representative Moriarty, why don't you go ahead with your next question?
Yeah, second question deals with registration as domestic partners. Is there a procedure for deregistering or unregistering, as it were? Does any Peggy or Mary, are you familiar with that?
Go ahead.
Yes, there's a termination process, and it requires, again, sending a form to the secretary. If you're this, again, this is registered domestic partners, requires sending a form, and there are various conditions that trigger termination, like you no longer live together, you marry somebody, whatever it might be. There's also just a question from Representative Reckitt. I believe these are sort of terminated de facto by operation of law when you marry.
In your experience, are there people who just go their separate ways and don't bother to follow the procedure?
Entirely possible. But I'm speculating. I do not know. I do not know of anyone who's done that. And frankly, it's, because employee benefit, well, actually, it's not tied to employee benefits. Never mind.
Thanks.
I don't think if you've separated from somebody, you don't want them making your, a lot of important decisions for you and so on.
Right. Okay, thank you.
Representative Thorne?
Thank you, Madam Chair. I sometimes get hung up on definitions and facts. I noticed the Oxford Dictionary definition of domestic partner is a person who shares a residence with a sexual partner, especially without a legally recognized union. And the main definition of a domestic partner says domestic partner means one of two unmarried adults who are domiciled together under long-term arrangements that evidence of commitment to remain responsible indefinitely for each other's welfare. And I guess my question is, albeit maybe far-fetched, but we're talking about consistency in laws regarding domestic partners. Some married people don't live together and they're allowed to remain married. And I'm curious what the vetting process is to declare a domestic partnership. And my mind goes back to, there was a movie, I Now Pronounce You Chuck and Larry, with Adam Sandler and Kevin James. And they did exactly that. They formed a domestic partnership or marriage, I'm not sure now what it was, so that one could get the other's health care as a spouse or a domestic partnership. And I don't know how much of that goes on in Maine and what the significance is, but I'm just curious if anybody's aware of what the vetting process and of declaring a domestic relationship to get that on paper, and does that go beyond if that's the last they spend and one goes their way and the other goes their way, there they go, they're domestic partners, they don't live together, and flies in the face of the definition, only to get those benefits, or whatever it may be. And I don't know if that's a question for Mary or for Peggy, but I'll refer it to Peggy. If you want to defer it, go ahead.
If you
Right.
want.
I think that insurance companies have the ability now to vet and make sure that they meet the requirements of the statute. I believe the insurance company would still have the authority to make sure they meet the definition, even if it's a changed definition. Does that answer your question? I mean,
Right. I'm always thinking worst case scenario as far as using the system. How can it be abused, even though it may be a good intention, well-intentioned to help those who are honest and near and dear to each other, but then there's always the loophole of, nowadays the stigma doesn't follow the way it used to, and sometimes if it's a benefit financially, then some people are open to abuse. So
I mean, if you're filling out a paperwork and you're committing fraud, then that is, a violation of itself, regardless of whether you're married or a domestic partner, or, whatever it is that you're declaring actually exists when it doesn't, then you are committing fraud. And depending on how you aver that that's true, there are different levels of prosecution possible.
as far as there's no follow-up or investigation to prove that this domestic partnership exists.
I wouldn't have a clue as to whether insurance companies follow up on that now or if they would in the future.
Okay, maybe somebody down the road could answer that. Thank you, Madam
And
Chair.
employers and representative, it's, this is exactly the kind of concern that has motivated trying to come up with definitions and factors as exist in the insurance statutes, as exists in the registry, and also as exists in the probate code definition that this committee approved of some number of years ago. And certainly, at least on an informal basis, these kinds of things can bubble up. And it's not only insurers that could try to recoup improperly gained benefits and costs to them, but employers.
And I'm curious why they took sexual relationship out of the definition for the main statute. And how long ago? That's a story for another day, I guess, but
yeah,
they're not including that in the definition of domestic partners. So
yeah, it's not in the definition of marriage. It's not in the definition of domestic partner. And it is sort of as a holistic definition, whether in the probate code or others, something that it's not everybody that agrees to live with someone and commit indefinitely to their common welfare in an exclusive relationship. So you get very close to that without saying so.
okay. Thank you. Thank you, Madam Chair.
Thank you. Senator Kime?
So I think maybe we're going to be exploring this and tabling it and exploring more information about what other committees are doing. I don't know, but I certainly want to explore the idea more of just making it registered, and only because it just seems like we're trying to come up with all these ways of from the outside of legitimizing someone's relationship when they themselves haven't necessarily taken the time to legitimize their relationship in some way. And I understand like that can come from a point of, wanting to be compassionate in a situation that they found themselves in. But I also think that because we haven't created that as an expectation, that then we kind of keep it going, and people find themselves in bad situations because they haven't taken a step to solidify their relationship. And it does get problematic when they want to go in the hospital and make, I've lived through this with people that are close to me. So I feel like we as a legislative body should look at what we have in front of us, which is a need to really have a legal construct around certain relationships, and put something in there that's definitive, that isn't, oh, well, you've been living together for a year, so now you're considered. I mean, what is that? How is that our decision to say, all of these external factors like that we're then making these decisions? Well, you look like you're committed, so we're going to go ahead and say, yep, you're a domestic partner. I mean, I just feel like that is not if we're going to create law, we should create law that makes it very easy for a person to make their own decision about what their relationship is, rather than us stepping in and saying, well, this is what it should look like, and therefore now you're legitimized as a domestic partner. So I would really like to explore further the idea that we make it very, very black and white, and allow people to make that decision on their own, and not us coming in from the outside to decide what's legitimate domestic partner and what isn't, because even the definition is somewhat vague, right? It doesn't a lot of people could be living together and not necessarily want to be a domestic partner. Or maybe they do. I don't know. But so I wanted to hear, Mary, your response to that. And then also obviously speaking to the committee as a whole to just consider that as a way forward, even though maybe it's a little bit messy right now.
Okay. Before you answer the question, Mary, I just wanted to indicate that Senator Keim, if you are interested in pursuing an amendment to this bill that would change it to registered domestic partnership, you may want to consult other people who could help you develop that proposal. I'm not sure that we have the right group of people available today. Is there anybody in the attendee space who you think would be able to help us as a panel explore that? No. Okay.
No, I don't.
So let's let Mary Bonato provide some information, and then I think it might be appropriate for us to take both a corner caucus and a brief break. Go ahead, Mary. Thank you.
Thank you, Senator Keim. A couple of thoughts here. One is I'm intrigued by your point about it's not for us to tell people what their relationship should look like. Let them decide for themselves. And I do think that that's actually part of the idea of the probate code definition, except that there are some guardrails around it that have substance. And the substance is actually very similar to, resonant with what already exists in Maine law around you're one of two unmarried adults, you're domiciled together, you're under long-term arrangements. And again, so far in Maine, that's been defined as 12 months. But here it's not defined. But it's long-term arrangements that maybe it's a shorter time, but it evidences a commitment to remain responsible indefinitely for each other's welfare. And so what I would say is that there are elements of this that really sort of seem to bespeak like holding yourselves out as a family, of caring for one another, of caring for children together, of some sort of financial enmeshment and responsibility in the different ways people support one another. So there's, I think, a lot packed in here, which is why, if I recall, some of the definitions or issues around the probate code, the Maine probate code, were the kinds of things people were thinking about here, that there are those people that exist. So I don't want to prejudge the discussion. I think the idea to table it is, this is generating a good conversation, so it might deserve some more baking time.
Thank you. And I know that a motion to table cuts off debate, and I did want to ask you, Senator Keim, would you be comfortable with tabling motion at this time to look into the registry registered partner issue further?
Well, I tend to like look at something and think, oh, well, maybe this is a solution, but it's not my bill and it's not my place really to kind of amend someone else's bill. So I think and I didn't put it forward. So I think if the committee wants to table and look into that, we do have a lot of bills in front of us, or, I think I would leave that up to the committee to decide, and also the bill sponsor.
Okay. Thank you very much. At this point, I feel like we have generated a lot of good conversation, as everybody has acknowledged, and I would ask for a motion to table. Representative Arnett?
Thank you, Madam Chair. Given the discussion, the questions raised, and also the questions raised by representatives of the Maine Hospital Association, I think we do need further discussion and work with the bill sponsor and advocates. So I would make a motion to table.
Is there a second? Seconded by Senator Kime. And I'll ask our committee clerk to to call the vote on the tabling motion. Thank you very much.
Very welcome, Madam Chair. Representative Galgay-Reckett.
We are not able to hear you, Representative.
I'd like to pass for a minute.
Representative Galgay-Reckett passes. Representative Newell. Representative Evangelos. Representative Poirier.
Yes.
Representative Poirier votes yes. Senator Kime.
Yes.
Senator Kime votes yes. Senator Sanborn. Senator Carney.
Yes.
Senator Carney votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
No.
Representative Babbage votes no. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Hagan. Representative Libby.
Yes.
Representative Libby votes yes. I will recall the absentees. Representative Galgay-Reckett.
No.
Representative Galgay-Reckett votes no. Representative Newell. Representative Newell is absent. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Senator Sanborn. Senator Sanborn is absent. Representative Hagan. Representative Hagan is absent. Madam Chair, I have 9 members voting in the affirmative, 2 in the negative, and 3 members are absent.
Thank you very much, Ms. Panett. And with that, the motion is tabled. The work session is tabled on LD 1804. And I want to thank everyone who has participated in and contributed to our discussion this afternoon. Representative Harnett? Okay.
Sorry about that.
That's okay. So committee members, we have several more work sessions to go. It is a little bit after 2, and I would like for us to take a 5-minute break and then resume. So let's say we'll resume at 2:15, and we will complete the rest of our work sessions going straight through till we're done. Thank you all very much. See you at 2:15. Committee members, if you've returned to your desks, can you please activate your video so that we can begin our work session? Thank you. All right, it is.
Anne, my piece says you've stopped my video.
I did, because when you walked away from your desk, it was stopped. So let me see what I apologize. I mean, it was still on. So
yeah, sorry. Sorry, I forgot.
No, that's okay. But let me fix it. I had forgotten that I did
Yeah.
that. I apologize.
That's all right.
I tried to fix it. Lois, did that work?
Apparently, yes.
Oh, wonderful. Okay.
Thank you.
Thanks,
I didn't
everybody.
I didn't take it personally. So.
Thank you. All right. Thank you for returning promptly from the recess committee members. We will now open the work session on LD 1786, an act to maintain consistency among Maine's non-discrimination statutes. And I will ask Peggy if she can do a bill analysis, but a slightly more abbreviated and focused one in light of the fact that it's nearly 2:30. And Peggy, if you could please focus on the amendments that focus on sections 14, 17, 18, and 19. And then the amendments, I think that'll get us started on the review of the bill. Thank you.
First, I apologize. I'm partly in the shadow. I have this great south-facing window and the sun is shining. So anyway, so LD 1786, an act to maintain consistency among Maine's non-discrimination statutes. The purpose of the bill is to go through to all the statutes. There are maybe 25 in all the titles that prohibit discrimination on some basis. And the idea was to use the categories that are prohibited discrimination in the Human Rights Act and apply them in all those situations. So code of fair practices, election laws, throughout the statutes. And some of that, what really raised concerns in the public hearing were the insurance statutes, because this bill as written would prohibit rating based on or establishing rates based on any factors that include age or marital status or sex, which are actually some things that insurers do use. And Senator Sanborn, I believe, authorized me to share this amendment that addresses those issues. Oops, let me get that up. So is this a good time to share the screen?
Yes, please. And I'll just let committee members know that during the initial public hearing on the bill, Senator Sanborn, who chairs the Health Coverage, Insurance and Financial Services Committee, did raise some concerns about changing things that would impact actuarial work and underwriting. And so then she offered to work on the language so that it wouldn't accomplish substantive change, but just update language. And and that is what Peggy is showing you. Thanks, Peggy.
Great. So sections 17, 18, and 19 you'll see are all in 24A, which is the insurance code. And so this amendment strips out what's in the bill with regard to everything except race, religion, ancestry, or national origin. Those are added in because it's recognized that those really apply even if they're not in the statute. Sex, sexual orientation, and gender identity that terminology is used rather than gender. You can see that gender is in the current law because that has been interpreted to mean those things. So that keeps the language consistent. The same with section 18. This changes creed to religion, ancestry, or national origin, it strikes out religion because we're just putting it in the same order in every place. And then section 19 does the same thing. Religion, ancestry, and then it already says gender, sexual orientation, gender identity. And so we're changing gender to sex. So that, I think that strips out, this is Dirigo, this is not the car insurance section, which is why sex is taken out of section 18. I believe that's a property casualty section. So I think this meets the need, addresses the concerns that the people representing the various insurance companies expressed. And I do have a draft of amendment to address the section 14 issue, which I mentioned in my bill analysis, if you want to see that. Can you see that? Did it switch?
Yes.
Oh, great. So this section 14, if you remember, I don't know if anybody talked to you about it, but people talked to me about including age in there means that anybody who has a state license or permit where the statute said they couldn't sell alcohol to a minor or tobacco products or engage in games of chance or gambling, this would set up a conflict. So if we take age out of this, then we can avoid those issues. So that's the proposed amendment to section 14. And then I can go back to 17, 18, and 19 if you'd like. But I'm going to stop sharing for now.
Thank you very much, Peggy. Representative Thorne, go ahead with your question.
Thank you, Madam Chair. It occurs to me as I'm listening to Peggy, why don't they just say you can't discriminate against anybody for any reason? Why is that? Why must we specify? Is there a reason why we can't be all inclusive of shall not discriminate against anyone without specifying all these different things? Am I missing something?
I think it's discrimination based on characteristics is the concern, or
Anyone for any reason. Why I don't know why it must be so explicit, because years or down the road, somebody's going to find a loophole, say, oh, we're not included in this because we identify as bunnies, and it's not explicitly put in there that people that identify as bunnies can't be discriminated against. So the statute's going to have to be updated. Why can't it just be all inclusive that can't discriminate against anyone for any reason?
is that a question for me?
It is.
that might be way
Is
over
that-
my head. I'm not really sure.
Is that language that is possible to say can't discriminate against anyone for any reason?
I mean, I guess it depends what your definition of discriminate is. If it means you cannot grant somebody a license, you cannot refuse to grant somebody a license because they failed a test. Is that discriminating against somebody because they didn't meet the standards? Or, I mean, I think there needs to be a line somewhere. I understand what you're saying, that are we listing everything? Are we exhaustive in all the things that we want to protect?
And I'd like to respond as well, Representative Thorne, because we, in our state laws, we have the Maine Human Rights Act, and the types of protections in the Maine Human Rights Act are illegal discrimination, but there's other types of discrimination that aren't illegal. Like if you're hiring someone to be a crane operator and you've got two candidates and one has a license to operate a crane and one doesn't, technically you're discriminating against the one who doesn't have the license if you don't hire that person. That type of discrimination is not illegal. It's just what's outlined in the Human Rights Act. And the purpose of this bill is actually to make those categories in the Human Rights Act consistent across our statute so that we're not juggling the kind of different standards that it seems like you're concerned about as well.
Okay, thank you for that.
Yeah, thank you for the question. Representative Harnett?
Thank you, Madam Chair. And in the interest of framing the discussion on LD 1786 as we move forward, I make a motion ought to pass as amended, including the amendments just outlined by our analyst.
Is there a second, committee members? Seconded by Representative Babbage. And now we will turn to committee discussion. Thank you both. I actually would like for us to hear from representatives of the insurance industry who raised concerns. Before I do that, I see that Representative Harnett, is your hand residual? And Senator Keim, would you like to go ahead with your question? And then we'll hear from the insurance industry folks.
No, I think it might be more succinct if we hear from them and we just kind of take that part off the table. And then I do have other questions for Peggy walking through the bill.
Okay, great. Thank you. So I'm going to bring over Bruce Garrity and Charles Sultan, who both reached out to me regarding the insurance concerns. Yeah, I want to thank you both for joining us this afternoon. My apologies that we weren't able to circulate the amendments to 17, 18, and 19 in advance. It's been a very hectic week with lots of confirmation hearings and work in the Judiciary Committee. And so I think, Peggy, if you could please screen share those changes again, and I would just ask each of you if you could help the committee understand whether these changes address the concerns that you raised at the public hearing. And you can proceed we'll start with Mr. Garrity perhaps. And if you need some more time to look at it, that's fine as well. And Peggy, could you increase the size of the document just a little bit? Oh, that's awesome.
I see you were watching me peer closely at my screen. Unfortunately, I have this on a laptop that doesn't have a very big screen right now. And I appreciate the opportunity to be brought in, Senator.
Yeah, I can't talk right now.
With regard to section
I'll call you right back,
18,
okay, when I can.
with regard to section 18, I think that that language works. And that was the section I was primarily concerned with. I think that section 17 works as well. Charlie, you had talked more about section 17 than I did. Did you have any other thoughts on that one?
No, thank you, Senator Carney, for asking us to comment. We are just looking at it. I think my read is that we're okay, that the underlying terms are terms that we would never use to underwrite and so on. So I believe it should be okay.
Yeah.
That under section 17, that's fine as well as 18.
And we appreciate the committee's attention to this issue and consideration of the concerns we raised, Senator.
Thank you. I see that Senator Keim has her hand raised. Did you have a question, Senator?
Yes, and I just, while they're here about this specific section, so there isn't, so this sex is still in there under section 17 in the amended version, and that isn't a consideration when it comes to insurance.
Yeah, it would be in section 18.
Right.
Section 17 deals with insurance scoring. And so there it is not a factor.
Right.
So they both deal with insurance, but they're doing very different things. And so for the factors used in insurance scoring, sex is not a factor at all. And 18 deals with rating and underwriting. And there, as I think Mr. Garrity and the Bureau testified, there are some benefits to being a young woman versus a young man, especially as a teenager, and also, in other instances. So it is still a useful, known characteristic for, being as accurate as possible in underwriting a policy. So the way it's drafted, it works actually well for us. It's fine.
And then just one other follow-up to that. So there's also still, I think, or at least some insurance will ask for students, if they have good grades, they get a lower rate as well. And is that a typical consideration?
Yes, that's many, if not most, all policies do allow for good grades, academic accomplishments, and things of that nature as a factor, and that isn't based upon gender at all. That's based upon academic performance.
Okay.
Right. So they're not affected at all. So that would still occur without it.
Right.
Thank you.
And Representative Reckett, is your question also for Mr. Garrity or Mr. Sultan?
I don't know which.
Okay, go ahead.
What I'm trying to get clarity around, and I now understand that 17 deals with insurance scoring and 18 on rating and underwriting. I still don't know what 19 is or 14 is, and so I would appreciate it if you could just tell me in the shortest amount of time what 19 refers to, what section that refers to.
That deals with Dirigo Health. And
okay.
Senator, I can't hear anything right now.
Oh, it says Dirigo Health, Representative.
Thank you. And 14?
I don't know.
Don't know. Okay.
Yeah, 14 doesn't involve insurance, Representative Reckett, and we'll switch to that in a moment.
Okay, thank you.
Committee members, are there any other questions regarding the insurance, the provisions of this bill that relate to the insurance code, Title 24A, that you might want to ask Mr. Garrity or Mr. Sultan? If so, please raise your hand. Okay, I am not seeing any. Thank you both very much for spending a big chunk of your day with us today and for your help with these sections.
Thank
Returning
you.
to the attendee part of the meeting.
You want me to stop sharing?
Let's just, if Peggy, if you could return us to the amendment to section 14, please. This is and walk us through that one more time, please.
This amends, there's a general discrimination law in Title 17. And this might be the only section left because it's been put into other places. So this applies across the board for anybody who holds a license from the state or a subdivision of the state. So dispensing of food or liquor for any service or for any service or an entity, if they're authorized to do business in the state, may not withhold membership, its facilities, or its services. So you basically can't discriminate on account of actual or perceived, all these other things that are already in the Human Rights Act. And the bill added in age, and the concern was that there are plenty of things that people are licensed to provide services where they're limited in providing those services to people on account of age. And the idea was to take that out of this section. And I don't know if that means that in the future, somebody's going to look at this and try to figure out a way to make sure that age discrimination is not happening where the state already says there's a limit. Might be an opportunity to kind of investigate those situations and write them in as exceptions, as opposed to just taking age out altogether. But this would just make it easier to go forward with the change to Title 17.
Yeah, so for example, an establishment couldn't serve alcohol to somebody under the age of 21, and that's part of their licensing requirement. And so this amendment takes into account the fact that there are some permissible types of discrimination, so to speak, with regard to, for example, serving alcohol.
Correct.
Representative Reckitt, do you have questions about section 14? Peggy, could you end the screen sharing, please?
Absolutely.
Thank you.
I'm fine now. Thank you.
Okay, thank you for raising the question. Senator Keim?
So I have a couple of questions for Peggy. One basic one, the amendments that you just shared with us, I didn't see those come through in email. Do we have those in any form yet?
You do not yet, and I can I upload them now if you'd like. Well, it'll take a few minutes.
That's fine. Yes, I would like to be able to print them off. And then so when I'm looking at the this comparison sheet that you did for us, and I don't know what this thing is called, but I will say that my question is on page 5, where you put the current law, and then you sort of helped us put it in a graph for us to see the changes. On page 5, there's a section called that is a push poll, and I don't even know what that is. So I was wondering if you could tell me a little bit more about this, a list or directory, that part.
Right. I mean, it might help to have the whole context of that, since I didn't give you the whole section. So this is under campaign financing. 1014B, push polling. So here, you know what? I'm going to share my screen so we can all learn together. So push poll means any paid telephone survey or series of telephone surveys that are similar in nature, that reference a candidate or group of candidates other than in a basic preference question. And when it goes through A, B, C, D, and E, and this is one of those. So, and these all have to happen in order for it to be determined, for it to be defined as a push poll. So a list or directory is used to select respondents belonging to a particular subset or combination of subsets of the population. and other such as race, sex, age, ethnicity, party affiliation, or like characteristics. So, and this would add in the other characteristics that are being protected by this bill or being recognized by this bill. And then push polling, here's the requirement of push polling in subsection 2. And so there are restrictions on how they go about it. A person may not state or imply false or fictitious names or telephone numbers when providing the disclosures. So it's, I don't really know how push polls work, and if Janet were on the line, we could ask her, because she does the Veterans and Legal Affairs Committee.
So I guess maybe what I'm wondering is, so they're saying that you can create and do a push poll based on these characteristics, or that you cannot?
You can, that's part of the definition.
So it's very, what is the, I guess I don't even understand the point of adding these into this. So you can do a poll and you can create a list based on their demographic or political characteristics, which makes sense. We've all had that happen to us. But you can also narrow them down to have a poll based on a person's color and sexual orientation. I mean, is that what we're saying here? Is that what this change is saying?
Right. I think if you go on, those are all things that can be part of a push poll, but the definition of a push poll is they're not collecting or tabulating survey results. They're not actually collecting data from people that they're talking to. They're using it to, it's paragraph E, the survey is primarily for the purpose of suppressing or changing the voting position of the call recipient. And then subsection 2 says push polling must be conducted in accordance with this subsection. A person may not authorize, commission, conduct, or administer a push poll unless during each call the caller identifies the person or organization sponsoring or authorizing the call by stating this is a paid political advertisement by whoever. So if you're actually selecting the recipients of this poll based on any of these characteristics, and it falls in, it's not really a poll, right? Because you're not collecting information so much as you're trying to get whoever's receiving the call change or suppress their vote or get them to vote in favor of somebody. So it's not really a survey, and it's not, I guess I'm not even sure why we call it a poll, but it just, it is saying that you, if you use these characteristics to identify who you're talking to for these purposes, you must make sure that you say this is a paid political advertisement by whoever. So what it's saying is right now, I'm not sure that these characteristics wouldn't fall under this law, because A says based on demographic or political characteristics such as, so it's not limiting it right now. So somebody could argue that this push poll is being conducted looking at it's based on the people are selected based on sexual orientation or gender identity. If that's the case, and you meet all the other criteria of what a push poll is, then you have to make sure you also do the things, you also comply with subsection 2. So if you're identifying the recipients of these calls based on gender identity, you're not collecting data from what you're asking them, then you need to make sure you say this is a paid political advertisement. So
Okay.
I'm not sure it's changing the substance of the law so much as making it very clear that there are more characteristics that are covered by this than what are just listed in the statute.
Okay, I think I understand it, trying to capture every type of poll that might be targeted. It's
Right,
trying to
and so
capture all the targets, I guess.
I think so. I think it's just being more specific. It's not really the law. It already says you can't do this really, but it just makes it more specific to anybody who wants to target any of these categories that are protected by the Human Rights Act, that are not already listed in the statute. It makes it very clear that if those are your target, that's who your directory list comes from, then you have to comply with the rest of the statute.
Okay.
That was a learning experience for me. Thank you.
Me too. Okay, I also had a question about, I guess I'm going backwards and forwards here because I started in the middle, but that's all right. So on page 8 of that same analysis that you gave us, I was wondering, so it says admission of pupils to the non-public schools, and I know in other states, I don't think in Maine, but I know in other states there are schools that are only for Black students. So is that not allowed in the state of Maine, I'm assuming, at all, ever? According to law right here, is that right?
Right. I am not aware of any school that would operate in the state that would be based on race.
And this clearly says it would be against the law, right? That's what as I'm reading it. Not that it's a change, but I just need to understand.
Right. But this section 23 is in Title 30A, which is the, municipalities and counties statute. So there must be some kind of a, why am I thinking addresses schools and libraries with regard to municipal finances and expenditures. I guess it's saying that you can't spend municipal money, public money on schools that discriminate.
Okay. Okay. And then, so going down in it, on that same page, it says class of persons to whom residential real estate may be sold, and oh, maybe it's not there. Oh yeah, there it is. So I'm wondering, so real estate, that we have facilities in this state where, it's a older community and they don't allow children or whatever, or they, so if we have this, then do we not have, elderly or senior housing? How does that affect that?
That is a good question. These are affordable housing covenants. I think there was a question raised about this, and I'm not exactly sure what it is. I'm trying to remember if I had a question from Maine State Housing about this section in particular.
So, and this is, only affordable housing. It's not just in general real estate transactions. It's only for affordable housing that I am assuming the state subsidizes in some way. Is that, am I understanding that correctly?
I'm reading the definition of a affordable housing covenant. And I think it might be administered by the Maine State Housing Authority in some cases under the Affordable Housing Partnership Act. I don't know if anybody else has more information about this. I'm sorry that I'm not prepared on this section.
No, I think I'm actually the one who's not prepared. I had intended to reach out to Maine State Housing before today's work session, and I did not have an opportunity to do that. I believe the suggestion by Maine State Housing was to eliminate the reference to age in section 24. And
and what about, I don't know, but what about familial status? I know there are housing, I don't know what they're called, but housing residential areas that it's kind of all old elderly or senior housing or whatever, but they actually don't allow children. I don't know, but I don't know if that would be an affordable housing situation or not.
yeah, I would like to run that question by Maine Housing, Senator Kime. And I'm glad, I appreciate you raising it.
I'm a little concerned still that I may not completely understand the impact on the non-public schools. I'm assuming it's only if it's in some way state funded is the idea here, but it says admission of pupils to non-public schools. So I think, Peggy, I just need a little more clarification there if we're in fact making this rule for all schools, even if they don't have any state funding.
And this is, which section are you looking at? I'm sorry.
So in that same bill analysis that you made us on page 8, and I'm sorry, I wrote all my notes on that and not on the bill itself, which would have probably made more sense, but I can find it in the bill.
$23.30A.
Yeah, it's section, it's page 7 of the bill, section 23, and it's title 30A, section 5724, subsection 9.
Right, and I see the paragraph in there. A municipality may provide health or remedial services to non-public school pupils as authorized by this section, only if those services are available to pupils attending this public school serving the municipality. I see there's another benefit of non-public school pupils. Well, that's still about health and I see your question. And I guess I would need to spend a little more time to figure out how to answer that.
Okay. Okay, thank you. And I have another explicit question on the bill if I can. I know I have a lot of questions here, but I can give someone else a minute if they want to.
I think your questions are helpful, Senator Kime. Why don't you continue?
Okay. So I was hoping, Peggy, that you might help me understand the I know I need to figure out where this is in the bill because I'm on page 4 of your analysis draft, and
that works too.
Okay, and the very last block where it's a person, firm, or corporation holding a license under the state of Maine or any of its subdivisions. So there's some language change there, which is just business entity organized in this state, which I assume is just an updating of language and not really a change of who this is covering.
Right, that's my understanding.
But this in itself, this seems like a really large change, and it kind of brings me to one of my bigger issues with the bill. But do you have a way of helping us understand who this might be applying to? It's so broad that, practically speaking, I have a difficulty just kind of making sense of this realistically. Like, who is this? So every business entity organized in this state. So just literally drive down the street and it's every single person.
That's my understanding. So the first part is about anybody who has a license.
Peggy, can you just point us? I'm sorry, I'm following along with the bill
Just
text.
to section 14 of the bill.
So the one that we've talked about a little bit ago.
Right.
Okay.
That we were talking about taking age out of.
Okay.
But it does add in actual or perceived color, sex, sexual orientation, gender identity, physical or mental disability, ancestry, in addition to race, religion, national origin. Now, if any of these are already a public accommodation or an employer, a lot of these things are already prohibited. Not everything in employment is prohibited discrimination. But certainly if they're a public accommodation, these things would apply. Maybe not familial status in all situations. But you're right, it's a very broad, it's a very broad section.
So that is kind of my question, is who are we capturing that we haven't captured previously with these changes? That I would really like to have some more understanding of.
Right, I can understand that you don't want unintended consequences. This is intended to make this law consistent with the freedom, the Human Rights Act. So it's clear that there aren't any conflicts looking at this law or looking at the Human Rights Act, that everybody is covered the same. So this is from a chapter called in Title 17 called discrimination. And it used to have 3 sections in the first part. One was race, creed, or nationality. This one was added as state licenses. And then there was a provision about blind persons with guide dogs. That was repealed and replaced with the model white cane law. And also, no, that's all I have. So this was intended to be broad. It was, looks like it was first enacted in 1969. I'm not sure when the Human Rights Act was enacted, but it was certainly broadened over time.
Yeah, I think that predates the Human Rights Act, and it hasn't been amended since 1987. And so I think that's why so much updating needed to be made with that particular statute.
Right, so it looks like the Human Rights Act came into being in 1971.
And in this section, we're removing age but not sex, or we are moving. Is that correct?
Correct. That was the proposal.
So I think maybe I should let Representative Harnett go, but I have a few other questions, but maybe I should let Representative Harnett go, so I'm not being a mic hog here. Thank you.
Thank you. Go ahead, Representative Arnett.
Thank you very much, Madam Chair. And I'm just trying to grasp the point of this statute, as I understand it, this bill, is to find places in the law where discrimination has been outlawed at any time in Maine's legislative statutory history, but making sure that they now include all of the additional categories that have been established under the Maine Human Rights Act, perhaps since those laws were originally enacted. So adding things like color, sex, sexual orientation, gender identity, physical or mental disability is simply bringing the anti-discrimination, making sure that all of the categories that we have determined as a state that entities should not be allowed to discriminate upon, based upon, are in all of these statutes. Is that, am I making sense?
Is that a question to me as a sponsor, to the analyst?
I think it's a question to the analyst because she was shaking her head yes, so I liked her answer.
Right. I think that's, you're much more succinct in explaining it than I am as this whole bill. I'm much more a detail oriented person. So your bigger brush, your broad brush explanation makes a lot of sense to pull all these pieces together, I think.
Okay. Thanks. And I don't want to cut off the questioning, but and then we are determining places where some of those categories, such as age when it came to, or gender when it came to driver's licenses, might not be appropriate or for insurance rating. So we pull some of those out, but otherwise it's going to be all of the categories that are already covered by the Maine Human Rights Act in the state of Maine.
Yeah, thank you, Representative Harnett. And I do want to address my fellow committee members and let you know that, I mean, I think that Section 14 is actually a really great example of why this legislation is needed. When you look at the law that underlies Section 14 of the bill, you see a law that was drafted in 1996 and amended in a piecemeal fashion, 1969, excuse me, and amended in a piecemeal fashion over 30 plus years. And a lot of changes have occurred in the language that's used in the Maine Human Rights Act since 1969, when it didn't even exist yet. And so what we've got is a whole bunch of different standards kind of scattered throughout our entire body of statutes. And there's no reason for that inconsistency. And in addition to that, there are a lot of reasons why you want to have one clear standard across the board so that we're not creating confusion among employers who have to comply with these laws, businesses that have to comply, courts that have to apply the law. That's the whole purpose of this legislation. I did want to, I feel that I do need to check with Maine State Housing about Section 24 of this bill, and I don't think we should proceed to a vote on it until I've had a chance to do that. And then it sounds like there might be some other questions that Senator Keim wants answered. And so at this point, I would ask for a motion to table so that we can do that additional work. Representative Evangelist, are you making the tabling motion?
Motion to table, Senator Carney. Thank you.
Thank you.
I still had more questions.
Okay.
We're going to be revisiting it when the main housing stuff comes in. So let's take it all up then. Otherwise, we're going to kill hours here and then no more time then. My suggestion.
Yeah, I am also happy to work with Senator Keim and try to answer the questions, and then we can bring them to the next work session as well.
Is that acceptable to you, Senator Keim, to get answers to the questions so that we can actually provide answers at the next session, at the next work session?
I think I would like to just be able to state them to the committee, and then I'd be happy with a tabling motion.
Representative Evangelist, are you able to withdraw your tabling motion?
If that's the wishes of the chair, I will.
Thank you. Hey, Senator Kime, do you want to just list your questions so that we can move on?
Yes, also in section 14 of the bill, I'm wondering if that would impact the ability to have Girl Scouts be for girls or Boy Scouts be for boys, and other, women's organizations that are for women. Or if that would also fall under the schooling part. And the other question that I have, in running this by some lawyers, is the whole idea of perceived, and whose perception is it? If it's perceived, how does perceived familial status, perceived age, all of those perceptions, and then the interplay between that and a person's perception themselves, or the person that's on the outside looking into the situation, the interplay between those two, I think we need greater clarity on as well. Thank you. That's about all of it.
Thank you. Okay, Representative Evangelos. Thank you that he had to leave the meeting.
I'm here. Yes, Madam Chair, what's your pleasure? We table it now?
Yes, you may proceed with your motion. Thank you.
Okay, motion to table.
Is there a second? Seconded by Representative Harnett. And I would ask the committee clerk to please take the roll on the tabling motion.
I will be happy to. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Newell. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Senator Kime.
Yes.
Senator Kime votes yes. Senator Sanborn. Senator Carney.
Yes.
Senator Carney votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Babbage, would you like to vote? Shall I go on and go back?
I'm trying to send him a message to unmute.
Let's try.
I'm sorry, I had great difficulty. I hit the wrong thing and lost my screen, couldn't do it. I vote yes, Madam Clerk, thank you.
Thank you. Representative Babbage votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Hagan.
Yes.
Representative Hagan votes yes. Representative Libby. I will recall the absentees. Representative Newell. Representative Newell is absent. Senator Sanborn. Senator Sanborn is absent. Representative Libby. Representative Libby is absent. Madam Chair, I have 11 members voting for the motion and 0 in the negative, and 3 are absent.
Thank you very much. So the tabling motion passes 11-0 with 3 absences. And we've given our analyst questions, and I've got a to-do list as well to bring back to the committee when we reschedule this for a second work session. Thank you everyone for the discussion today. So that will end our work session on LD, I've lost my place here, on LD 1786. And next we will move on to open our work session on LD 344, resolution proposing an amendment to the Constitution of Maine to explicitly prohibit discrimination based on the sex of an individual. And Peggy, did you want to begin with the bill analysis?
There. Yes. So this bill is actually a constitutional resolution that proposes to amend the main constitution to add a new Article 1, Section 25, to prohibit the denial or abridgment by the state of any political subdivision of the state of equal rights based on the sex of an individual. And then it goes on to say the legislature has the power to enforce this section by appropriate legislation. To amend the Constitution, a constitutional resolution must be approved by 2/3 of both the main Senate and the main House, then must be approved by a majority of voters in a statewide election. The governor, as she testified, is not involved in these, so it's not something the governor signs or can veto. You had a very long hearing. I tried to list everybody who had submitted testimony and who had testified in person. I'm not sure what other information you need. I tried to include the reasons that people argued in favor of it and the why people said it was not good to pass. A little bit of the background for information. The effect of a constitutional amendment is that it permanently changes a state law until the Constitution is amended again. It provides constitutional guidance about the limits of authority. It changes the standard of review for when state action is alleged to discriminate. So it would raise it to a more rigorous test of strict scrutiny. And that means the state can still differentiate on the basis of sex, but only if it serves a compelling interest and the action is necessary to further that interest, and there is not a less restrictive means of doing so. And then I've included the text of the 26 states that do have some form of an equal rights amendment that includes the term sex in their constitution. And I want to thank our researcher, Darlene Shores-Lynch, for putting that together for me.
Thank you so much, Peggy. And I see that Representative Moriarty, your hand is raised. Go ahead.
Yes. Thank you, Madam Chair. Peggy, this may be small potatoes, but I testified orally in support of the bill, but I'm not listed. On page 1 under proponents, I was between Representative Zager and Eleanor Smeal.
And I didn't list you?
No.
Oh, I apologize. My bad. I will correct it and post a corrected version.
Okay, thanks.
Committee members, let's start with any questions for our analyst on this. I am not seeing any questions. And Representative Reckitt, you are the sponsor of this bill. Would you like to speak briefly to the committee about the bill? And we're not able to hear you. We are still not able to hear you, Representative.
There we go, I think.
Yep, we can hear you fine. Yeah. Go ahead.
I'm trying to remember how many of you who are on the committee how many of you were freshmen? And I know there's a couple of you that are. And so I don't want to reiterate what I said at the public hearing, because I presume the bulk of you either heard me that day or listened to it later. And then I said, well, maybe I should, give you a impassioned plea, but I decided I would save that for the floor, presuming we get there. But I do want to clarify a couple of things. I have had significant discussions with a wide variety of people since the hearing. And I had considered broadening the classifications in this bill to cover other people other than, or other categories other than sex. And I chose not to do that in the end after consultations with the LGBT community, with the Native American community, with the racial diversity community. And I have decided not to do that. But I want to say to you that there are some issues that were raised by some of those folks that I believe did not need an additional language change in this proposal. So I'm not proposing any changes in the language today. However, I want to, before we vote on this measure, either here or in the House or Senate chamber, I want to submit, before we do vote to submit this to the voters, which is of course my desire, since all of us know we can't change the Constitution of Maine, only the voters of Maine can do that. I feel it's important to clarify one point. As a sponsor, I submitted its proposed wording, as I said, and I want to make it clear that I believe that sexual orientation and gender identity are subsets of sex and therefore are already covered by and included in sex discrimination. Often LGBT discrimination is about sex stereotyping, which could also be prohibited. I have no intent with this proposed constitutional amendment before you to exclude Maine's LGBTQ people from rights, which I believe will be protected by the proposed amendment. So that's really my short version of talking today. I'd be happy to answer any questions. I think you all know that I believe that this amendment is long overdue. The last time the voters in Maine had a chance to vote on this question was 1985. They voted it down by a small margin. I think that's something like 32, 37. I can't remember how many years ago it was, but it's long enough and the world has changed enough that I think it's time for us to give the voters another chance to consider this question. So that's my request to you, that you vote to send this to the House and Senate, and that hopefully they choose to send it to the people. So I'd be happy to answer any questions.
Thank you, Representative Reckitt. And Representative Harnett?
Thank you, Madam Chair. I move ought to pass on LD 344.
And is there a second? Representative Moriarty?
Yes.
Seconded by, so moved by Representative Harnett, seconded by Representative Moriarty. And Peggy, your hand is up. Go ahead.
I'm sorry, there's a fiscal note that needs to be added. It's a fiscal note that says, it's at the end of my bill analysis, that says the costs can be absorbed as long as there's only one question. If there are several referendum questions, then there will be a cost to that, to the Secretary of State.
And
so it's not an actual dollar figure. It's not an appropriation, but there is a fiscal note that needs to be added. So it really should be an ought to pass as amended motion. My apologies.
Thank you. I appreciate you catching that for us so quickly. Representative Harnett?
Thank you, Madam Chair. I would amend my motion, or ask to amend my motion, ought to pass as amended, to include the potential fiscal impact as outlined in the analyst's bill analysis.
Thank you. And do you second the amended motion, Representative Moriarty?
Yes, I do.
Thank you all. And Peggy, thank you so much for catching that. Committee members, we had a very extensive hearing on this, and I suspect that it might be something that we've already made up our minds on. I would like to know if anybody has any question or discussion before we move to a vote. Okay, I am not seeing any hands up, and so we will move on to a vote. So the pending motion is ought to pass as amended. And I think we're ready for the vote, and our clerk is here to call the vote. Thank you.
Thank you, Madam Chair. Representative Galgay-Reckitt.
Yes.
Representative Galgay-Reckitt votes yes. Representative Newell. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Poirier.
No.
Representative Poirier votes no. Senator Keim.
No.
Senator Keim votes no. Senator Sanborn. Senator Carney.
Yes.
Senator Carney votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Thorne.
Nay.
Representative Thorne votes no. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Hagan.
No.
Representative Hagan votes no. Representative Libby.
No.
Representative Libby votes no. I'll recall the absentees. Representative Newell. Representative Newell is absent. Senator Sanborn. Senator Sanborn is absent. Madam Chair, I have 7 members voting in the affirmative, 5 members in the negative, and 2 members are absent.
Thank you very much, Clerk Panett. And so the ought to pass as amended motion carries 7-5 with 2 absences, and those committee members have 48 hours to register their votes. And with that, we will close the work session on LD 344. And Representative Thorne, your hand is up. Go ahead.
Didn't know if you wanted to specify the minority motion.
Oh, thank you very much. I appreciate you asking the question. Go ahead and give, if you could provide us with your report.
Ought not to pass.
Thank you. And is everybody else who voted no in agreement with that report?
Thank you.
I'm seeing nodding heads. Okay, great. Thank you all. And so with that, we'll conclude the work session on LD 344. Thank the bill sponsor for bringing the resolve forward, and we will move on to our final bill today, which is LD 1818. And that is a resolve to reestablish and continue the work of the Criminal Records Review Committee. And I believe the bill sponsor is here, so I will bring her over to the panel. And I know that we received a report on the work of the committee earlier, a week or two ago. Time flies. And Peggy, I do not welcome Representative Talbot Ross. And Peggy, did you want to provide anything additional by way of a bill analysis?
I think that you can talk about whether you need to make any changes to it. I think it can go forward exactly as is, or you can amend it to specifically say that the appointees, that the appointing authorities should reappoint the people that they had appointed in 2021. You can do that, or it can just be assumed that that will happen. I know that Representative Moriarty had several questions, and I tried to answer them in the bill analysis. And there was a question about whether you would like to add an emergency preamble. Emergency preamble requires a 2/3 vote in the House and the Senate. The reporting dates are established by joint rule. If you change the reporting date, the Legislative Council has to approve it, but the Legislative Council looks at all studies anyway because they become legislative studies are funded off the legislative study table. There's a small amount of money set aside to fund those studies. I know that Representative Babbage asked for a side-by-side comparing several state laws, and I used my discretion to say you don't actually need that to vote on this bill, but you will when you talk about other the recommendations that this review committee gave you. So I did not include this in this analysis. I will say the Collateral Consequences Resource Center, the link is in the bill analysis in a couple of places, has voluminous information about the different states and their provisions regarding whether it's sealing or expungement or pardons or rehabilitation certificates. Just a word of warning that every state uses their own definitions as to what it applies to. And we'll definitely get into that a little more when we talk about the recommendations, whether you go forward with the recommendations. So the questions about this bill is, it reestablishes the commission. Do you need to, the commission has gone out of existence, so you do need to reestablish it. Do you need to say anything about the same people being appointed? It's the same appointing authority, so they probably got that message the first time. So I don't think you have to say that. And do you want an emergency on it so it will start sooner than 90 days after the second regular session adjourns? I hope that was helpful.
That is extraordinarily helpful. Thank you. And Representative Babbage, you can go ahead with your question of the analyst.
Yes, thank you very much for that, Peggy. And I totally agree with your assessment. The comparison of the three states I was looking for is really going to be helpful to the next legislature. So thank you.
Committee members, any other questions for Peggy? Peggy, I do actually have a question for you, because I've been kind of mulling this over in my mind about whether to include a request that the appointing bodies or individuals appoint the same people to the committee. Has that happened? That kind of direction been included before? And does it create other problems or complications?
I don't remember it happening before. Before the Right to Know Advisory Commission, Right to Know Advisory Committee was created many years ago, there was a committee established by the legislature to look at compliance with the freedom of access laws. And it was because a survey had been done, and there was a lot of non-compliance, partly because people didn't understand the laws. That committee worked hard for a year, and then it said, we're not quite done. One of our recommendations is to reestablish us. And so it was reestablished, and there were no changes in the membership.
So without the specific direction, the membership carried over?
I believe so. Actually, Judy Meyer was part of that committee way back when. I don't know if she has a different memory of that than I do, but I don't remember it being an issue at the time.
Mm-hmm. Thanks. Committee members, any other questions for Peggy? Representative Babbage, is your hand up? Oh, okay. Your hand is down. And Representative Moriarty, I see your hand raised. Go ahead.
If there are no questions for Peggy, I'd like to request a short caucus.
Okay, that's fine. We will take a short caucus, and then when we, Representative Sheehan.
Sorry to jump in, and this is a question for Peggy, and it is definitely a rookie question. But regarding the issue of an emergency enactor, I guess I thought that there was an emergency enactor on all of the short session bills, or is that a different kind of emergency?
That's a different kind of emergency. the Constitution says that bills in the second session can be for budget, something else, and things of an emergency nature. The legislature determines what that emergency nature is, as opposed to an emergency preamble, which requires, the Constitution requires a 2/3 vote to actually withdraw it from the people's veto option, because otherwise laws don't take effect for 90 days. So 2 constitutional issues.
Thank you so much.
Same word, different meanings.
Perfect. Thank you.
Thank you. And so with that clarifying question, Representative Moriarty, you had another question?
Yes, Representative Sheehan triggered an issue that I wanted to raise with Peggy. Peggy, if this were to have an emergency preamble, and if it were to pass by a majority, but not by the required 2/3, would it be deemed then to have failed?
Yes,
Or does
unless
it
you amended
pass
to take the emergency off.
if it's voted upon with a preamble in place and the 2/3 is not reached, it does not pass at all?
It does not pass. The people who are in favor of it could put a floor amendment on to take the emergency preamble off. And
Yes,
then
before voting, no.
before voting again.
Oh,
Right,
okay.
you could have the bill reconsidered, and it would be reconsidered, so it could be amended to take the emergency off.
Okay, good, thank you.
I hope I got that right, people who are actually sit in the chamber.
You did.
Okay.
Thank you. Okay, and so we will take a brief corner caucus. It's 3:34 now, so let's get back together at 3:45, everyone. Thank you.
Hey, Rachel,
Hello.
it's Jeff.
Hey, Jeff, how you doing?
Doing good, yeah. Caucusing at my little farm kitchen table here.
Yeah. It's good to see you.
Yeah, I'm gonna go feed the cow. I'll be back.
Yeah.
I'm feeling a little better. That's good, so.
That's excellent. That's
My
really
lungs,
good.
my lungs got damaged, Rach.
Say hi to Sheba for me.
I will.
So Jeff, I don't need you to explain your health situation in the public, but we're always thinking of you, so.
Yeah, no, I'm doing good. I don't mind. I don't care, you know. 2 newspapers
Always.
called me in the hospital, so I haven't got much choice at this point. I'm just, you know, I have these underlying conditions that compromise an immune system, and you read about this stuff in the paper, and, you know, there's a lot of people seriously ill. I didn't have a ventilator. I was there for 5 days, and my lungs aren't the same. I'm waiting on that. But I'm getting there. Feel good. I've worked through it, you know. I watched 7 Bonanzas and 6 Gunsmokes. So I said, I might as well be working. I mean, how many Westerns can you watch in the hospital?
I was gonna say, are you counting that as work?
Well, that was before Monday when you guys went, you know, I worked, yeah.
Oh, you look good. I'm glad to see you.
No, yeah, lost quite a bit of weight. It's coming back now, but it's a odd anomaly because so many people think it's just a cough and a sniffles, but not for a large part of our population. Just look at the Press Herald statistics every morning. Anyways, that's it. That's the update. Nice to
I'll
see
give you a
Rach.
call. Yeah, I'll give you a call.
Yeah, a lot going on, and oh boy, we'll talk.
Yeah, I know.
Yeah. Thank
Go
you.
feed your cow.
I will, though.
Okay. See you in a bit.
Hi, committee members. We're all returning from the caucus, and I would just ask if you are at your computer and can activate your video, please do so that we can complete our final work for the day. I was muted. I think our colleagues are not quite ready to return yet, so let's just give them another moment or two. Representative Evangelos, did you feed your cow?
The phone rang. I got busy and I'm still got my coat on, but she's yelling at me. I can hear her. No, I didn't.
Oh, poor things.
Well, still early. I usually don't feed her till 4, but I love those caucuses. Not really.
I'm going to refill my water glass. I'll be right back, everyone.
The R's not back. Is that what's going on?
Yep.
That is correct.
Thank you.
Another long day.
Any reconsiderations anybody wants to bring up?
Now, Representative Babbage.
It's probably fortunate that you're on mute, Lois.
Aaron, call me sometime and you still have to teach me how to pin. I tried myself and I couldn't do it. So
I started making a video about that and also how to make a standing appointment. So I will do that.
Oh, good.
It saves me every single day.
Yeah, well, I was going back and forth trying to find today, and I finally wrote down what day it was that the thing got sent to me, and so I could find it quicker, but quick still wasn't very quick. So it's
I'll
my
send you a little video.
oh, thank you. Yeah, it's all because I refused to take typing in high school, you know.
Me too.
Because I didn't want to be a secretary. That was it. So I knew that if I learned to type, I was destined. So I took mechanical drawing instead.
I like that.
Yeah.
May I say how dedicated Representative Sheehan is for sitting in her car for the entire afternoon?
Yes.
I hope you have heat.
And a boat. Well,
I got
she was
stuck
on the high seas for a while.
Yeah. Did you
I got
finally get
stuck
back to
on the
dry land?
island.
Oh,
I
you
am.
did?
I'm finally back in Biddeford now. So
Oh, good. Good.
it's never a sure thing if you go out to North Haven in the winter time. There's always a chance that the ferries might not run. And every time we tried to make a ferry back, it got canceled. So,
Wow.
All right, everyone. It looks like we are back from our virtual corner caucuses, so to speak, and ready to continue our work for the afternoon. So we're in the middle of the work session on 1818, and we've had the bill analysis and questions. We've asked some questions of our analyst, Representative Harnett.
Thank you, Madam Chair. I would like to make a motion on LD 1818.
Go ahead.
I move ought to pass as amended, with the amendment being the addition of an emergency enactor to the resolve.
And is there a second? Representative Evangelos seconds. And Representative Evangelos, did you wish to speak to the motion? Your hand is still up.
All set.
Okay, thank you. Representative Moriarty?
Thank you, Madam Chair. I have an additional amendment to suggest to section 4. And I guess it would go at the end, but I'm not certain that it would read substantially along these lines. To the greatest extent possible, the appointing authorities are requested to make the same appointments as were made following the effective date of LD 563, period. By reference, that was the bill that was approved by the governor last summer, and it was the resolve that established the committee in the first place. So we're not specifically directing that they get the same people, but to the greatest extent possible, we're asking that they do so. And the goal is to basically not lose institutional memory, which would happen if there were a whole new crew or a substantially new crew.
Thank you. Committee members, is there a second? Peggy, your hand was up first. I think you might have something we need to know.
I am not able to second. I would just say that we would cross-reference resolve chapter 121 rather than the LD itself.
Okay, yep, I see that on my copy, so that's fine.
Okay.
Thank you, Peggy, and thank you, Representative Moriarty. Representative Harnett?
Thank you, Madam Chair. Do I need to amend my motion to accept the friendly amendment offered by Representative Moriarty?
If you are amenable to that, then please do so.
I am amenable. I would just check with the bill sponsor yes, then I will amend it to incorporate the language with the reference just stated by our analyst.
And Representative Evangelos?
Second.
Okay, so we have a motion to ought to pass as amended and seconded. It's now the opportunity for committee discussion. Representative Babbage?
Thank you, Chair Carney. We're going to vote for ought to pass as amended. If we were to vote on the amendment by itself, I would probably vote nay, because I'm comfortable with putting that as part of the motion, but I certainly will vote for the OTPA if it is included. But I understand the institutional memory, and I think that the presiding officers will honor that with my informal encouragement, but that's just my 2 cents. Thank you.
Thank you, Representative. And the pending motion does include both the emergency and the additional language suggested by Representative Moriarty. Representative Reckitt? We're not able to hear. Yeah,
I have a question. if we pass this with both amendments, and I'm just worried about losing the bill because one of the amendments is people don't want, and then we end up with, I mean, I guess it feels simpler to me to do the first amendment that Representative Hartnett proposed. I think we all know that we want what, at least those of us that have talked about it, know that we want to have happen what Representative Moriarty has said. But I'm just worried about encumbering the bill itself with two different amendments. You think it's a problem, or we could get off both of them if we had to, or one of them? I don't know.
So can I clarify that the committee amendment, if it combines both those pieces and it is adopted, then the bill's reported out, and there's one of the chairs will move to accept the report that has the amendment on it. And then that becomes a thing. And if at some point you want to take the emergency off, I believe what you do is you amend the committee amendment to take out the emergency. Or if you don't want that restriction on the appointing authorities, you would amend it on the floor to just pull out what you no longer want part of the bill.
Right. Thank you.
Committee members, any discussion on the pending motion? I am, Representative Babbage, is your hand up anew, or is that residual?
I'm sorry, that is residual.
Okay, thank you. Is the committee ready for the vote? Excuse me, Senator Keim, go ahead.
Yes, thank you. I'm going to be voting against the current motion, partly because, when I'm in favor of the idea behind this. I think there are things that need to be looked at, but when when this commission was put together, it wasn't as balanced, and that was one of my issues when it was first created, is that I thought there wasn't enough balance so that the outcomes would be something I think that everyone would be more in favor of. And I've definitely, I think in our hearing, heard that some things, if people were in opposition or maybe didn't fall in line as well with what they wanted the outcome to be, maybe they were not as heard. That's what we heard in the public hearing. That's one of the takeaways I had. So I'm not in favor of putting together a commission set up in this way that that isn't allowing all voices to be heard, and is frankly too large, which is what was my opinion in the first place anyway. And that there wasn't, but I agree there wasn't enough time. That was one of the things we said when we some of us that were objecting last time said it's too big of an issue to take on in such a short amount of time. So I will be voting against the pending motion for those reasons, even though the underlying issue here is something I support. Thank you.
Senator Keim, can I just ask you, are you concerned with the addition of the amendment to try to reappoint to the greatest extent possible the current membership, or is your concern about the composition of the committee something different?
Yes, thank you for the question. Yes, when we discussed this, when we actually created the commission, I had concerns about the composition originally.
Thank you. Any other discussion, committee members? Looks like we are ready for the vote. So we are voting on the ought to pass as amended motion on LD 1818. And our committee clerk has joined us to take the vote. Thank you very much, Ms. Bennett.
Thank you very much, Madam Chair. Representative Galgay-Reckitt.
Yes.
Representative Galgay-Reckitt votes yes. Representative Newell. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Poirier.
No.
Representative Poirier votes no. Senator Keim.
No.
Senator Keim votes no. Senator Sanborn.
Yes.
Senator Sanborn votes, Senator Sanborn votes yes. Senator Carney.
Yes.
Senator Carney votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Thorne.
Nay.
Representative Thorne votes no. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Hagan. Representative Libby.
No.
Representative Libby votes no. I shall recall the absentees. Representative Newell. Representative Newell is absent. Representative Hagan. Representative Hagan is absent. Madam Chair, I have 8 members voting in the affirmative, 4 in the negative, and 2 members are absent.
Thank you very much. And so the ought to pass as amended motion carries 8-4 with 2 absences. Many thanks to the bill sponsor for bringing the bill forward. And
Thank you all.
huge thanks to our committee clerk and analysts for all their help today. And Peggy, you would like to bring something to our attention?
I just want to clarify what the motion is of the report is of the people who voted no.
Ought not to pass.
So,
Thank you, Peggy.
yep, thank you. Thank you for reminding me last time.
Yeah, and I'm rusty, everybody. I'm sorry. I should be asking without having to be reminded. So I appreciate your patience with me today. Anything else, committee members? I'm not seeing any. Is there a motion to adjourn? Moved by Representative Thorne, seconded by Representative Sheehan. And I think that ends our work for this week. See you all on Tuesday.
All right, thank you
Take
all.
care.
If you can send me the vote sheets, I'll register my vote.
I will absolutely do that.
Thank you.
Okay, be well.
Take care.
Night, Lois.